Mr. Sarve?
Yes, my lord, there are some preliminary points which we wanted to raise last time, and your lordship said your lordship would see it. Whether your lordship should at all go into these questions, because my lord, that has to be raised now, not after the hearing is over.
Let's do this. Let Mr. Sibal open the case. Then we can
Yes.
take a call. We'll have some idea of how it's proceeding. We, of course, have with submissions. Then we can
Yes.
take a call. All right. Why don't you tell us just in bullet point form?
Yes,
what
yes.
are the
I just
issues?
wanted,
Just
I
one, two,
wanted
three, four.
exactly,
We have some.
I wanted
Just a minute
exactly,
or so, and then we can go on.
I wanted exactly 3 minutes, my lord. Firstly, the Nabim Rebia correctness point, which Mr. Sibal wants to argue. And if your lordship have my submissions, just for convenience, on page 3, I have given chapter and verse from his writ petitions when the petitioners are relying on that judgment. My lord, when the new speaker got elected and the defection petitions got transferred and they challenged, they have filed petitions in your lordship's court saying, relying on Nabim Rabia saying the new speaker should not hear the matters.
But no, but Mr. Sarve, you are opposing a reference of Nabim of
Correct,
Rebia.
my lord. As are the petitioners are relying on it.
Let Mr. Sibal argue it, and then you can always respond. That
No,
we'll have
I'm
to
sorry.
hear both the sides. Anyway, we'll be hearing both
No,
the sides.
I'm not on merits. I'm saying, my lord, a judgment which they are relying on, they are now questioning the correctness of.
No, but that we will.
That we'll consider. We'll consider that. We'll bear that in mind.
Very well.
Yes, Mr. Sibal. Yes, Mr. Sibal.
Yes. So as I was saying, Millers, that both the law and those who interpret the law was hoping, Millers, that this would serve the cause of justice. But what's happened over the years, Millers, that the politician is far more artful. And Millers, in fact, the working of the 10th schedule and in this context has actually served the cause of political immorality. And this is a quintessential case of what that political immorality is all about. Now, Millers, as far as Nabam Rebia is concerned, let me just briefly tell your lordship what the submission is going to be, and then I'll go into the details. Millers, Nabam Rebia says that when a notice is issued to the speaker seeking his removal, the moment that notice is issued, Millers, he cannot act as a tribunal under the 10th schedule. As your lordship knows, Millers, that sessions take place, one session has to take place within a period of 6 months of the previous session. So, Millers, if, for example, a notice is issued and there are disqualification petitions pending, and a notice is issued, Millers, just after the session is over, Millers, for 6 months, Millers, the tribunal cannot act. This is the consequence of Nabam Rebia.
That once, according to you,
Not according to me.
right.
Yes.
Once notice is given to the speaker for his removal, then he is disqualified. And so to speak, he has to stay his hands then.
Yeah, he has to, Millers, that means the 10th schedule there must be a hiatus, Millers, in the functioning of the 10th schedule. I mean, this is a position in constitutional law
That is cleared.
cannot be accepted. Millers, constitutional authorities can never be in hiatus at any point in time. May it be parliament, may it be government, may it be courts, may it be election commission. No constitutional authority constitutionally pauses at any given point in time in the history of the nation, in the functioning of constitutional democracy. It cannot be. And the consequence of this judgment is, and this is really the basic flaw in the judgment, that the moment a notice is issued, and the notice is issued, Millers, under 179 in the context of the state of the Constitution with respect to his functioning in the assembly. But the consequence of that is that the speaker not just does not function in the assembly, he also is a tribunal. And the consequence of that is that his functioning as a tribunal is state. And this has now become a device to ensure that your disqualification petition is not addressed by the speaker, is not dealt with by the speaker. In the meantime, politics takes over. You topple the government. You, Millers, swear in the chief minister. And then, Malas, what happens is, then this is in limbo. This goes on, Malas. And then you have your own speaker, and Malas, history has shown since 1985, speaker after speaker, speaker after speaker. Malas, in the context of how speakers have functioned, Malas, they always support the political party who have anointed them in that position. When it comes to Malas, the opposition, the proceedings are expedited. When it comes to that government, Malas, the proceedings are stayed. Malas, this cannot. Malas, that is why I personally feel, and this is only my personal opinion, that the minority in Holohon was right.
But then, are you asking for reference of Quixote?
Malas, personally, I think that must be.
Then
Malas,
it works out. Then
two judges held, Malas,
they have held it.
that this is unconstitutional. This whole is unconstitutional. Why? Because Malas, the speaker can never act as an unbiased umpire in the game of politics. And we've seen it happen, Malas, and I'm not saying this, judgment after judgment, whether it is Jagdeep Singh.
The entire 10th schedule depends on speaker.
That's right.
In the center.
That's right. I mean, this is time for us, Malas. It's time for us. It's time for us, Malas, to actually relook both this Nabam Rabia as well as the 10th schedule. Because it has created havoc, Malas. Governments fall because of political machinations, and only because you issue a notice. Then, Malas, it's a more interesting thing. Then I'll come to the details, Malas. Now, I issue a notice to the speaker. I have no intention of taking it forward. I may have no intention, because a mere notice can be issued by one member of the Legislative Assembly or one member of Parliament, and he stays the functioning of a constitutional authority. The moment a notice is issued, then, Malas, when the session is held, Malas, so if supposing it is issued in between sessions, say 4 months in between, for 4 months nothing will happen. When the session is held, Malas, it has to be under 179, 14 days notice has to be given, and under Maharashtra Assembly rules, 7 days notice has to be given. Then, Malas, then a leave is sought from the House whether the individual can actually move that resolution or not. Leave is sought. Malas, and if 29 members of the Maharashtra Assembly do not stand up and support it, Malas, the notice is dropped. If 29 members, Malas, approve it, then the resolution is moved. And at the time when the resolution is moved, the speaker against whom the resolution is moved, Malas, cannot sit on the chair. That's the only time. He can vote. He can make a speech, but he can not sit on the chair. Somebody else will sit on the chair. So he can't be a judge in his own cause. That's the only time that the speaker, somebody else becomes the speaker. So till the resolution is moved, there is no actually motion against the removal of the speaker.
Yes.
Till the resolution is moved. Here, Malas, the 5 judges have said, moment a notice is issued, the speaker becomes, as a tribunal becomes dysfunctional.
If you are seeking a reference of Nabam Rabia,
Yes,
now,
yes.
can we look at it so that,
Yes.
read it, of course, so that we can see how...
Yes, I'm showing you, Lordship, the judgment itself. Volume 2.
Compilation volume 2, page 960.
Judgment compilation, volume 2, page 960. Oh, volume 1? Okay, sorry.
Volume 1?
1 or 2?
I'm so glad that we have brought some order to our functioning as a constitution bench by having common volumes and, everybody on the same page.
No, that's right. It's a great
Mr.
step.
Sibal, what are you doing with paper in your hand?
Manas, I am learning, Manas. Actually, I am learning.
Yeah, come on now.
I have it on
that
my
paper.
iPad also.
Your junior is there, she will assist you, use the...
Manas, I allow me some hybrid in the meantime.
We're not asking you to sit down in favor of your junior. But we can certainly issue a 142 is very broad, right? So
Yeah. No, Manas, actually, I've been doing this for several days now. I should be fine next time I come before your lordships. Manas, before I read Rabia,
anybody who wants another training session from our team, we'll have a training
No,
session.
Manas, I would love it.
They are all Last time they had held it when you
This
were doing
weekend I
the, when you did
this
the
weekend I
NCD matter.
No, no.
So
Let
which
me
page
tell
is
you,
that?
before
Which
you
page is
read
that?
Rebia, what Rebia was about.
973 PDF.
PDF page 973.
Yes.
Before you read it, let me tell you what Rebia was about. Well, Rebia happened in the context of the Arunachal Assembly, wherein Malaj, in 2015, sometimes on 15th October 2015, the next session of the Assembly, on the aid and advice of the Council of Ministers, was fixed as 16th of January, 14th of January 2016. Right? In the meantime, as has happened to the Congress party often enough, lots of people were wanting to defect to the other side. So a lot of letters were written to the governor that the chief minister, Nabam Ruki, is not behaving in a proper fashion, that there are a lot of allegations of corruption against him, we don't like him. And these letters were exchanged with the governor. Mullahs, when this was happening, the Congress party met and said, look, this is all illegal activity and you are liable for disqualification. So to cut the story short, Mullahs, sometimes in November, a notice was issued for the disqualification of 21 MLAs of the Congress party. And that notice was fixed for the 16th of December for their disqualification. When the governor realized that this happened, Mullahs, a notice was issued to the speaker that you cannot decide this issue. So a notice for removal of the speaker was issued. That's how one of the issues came up. The governor, Mullahs, in that context, knowing that these people may be disqualified, preponed.
He preponed the, yeah.
He preponed the session to Mullahs the 14th of January. December, 14th of December. And on the 9th of December, he sent a message to the House that this is how you will conduct your proceedings. So, two issues arose for consideration. Number one, does the governor have the discretion to prepone the session? Number two, can a governor give a message to the speaker as to how he is to conduct the proceedings in the House? Those are the only two issues.
The main issue.
Right.
When we argued the matter, Justice Mishra said, but you know, there is a notice against the speaker for his disqualification. That question didn't arise in the case, but we would like to decide that. And therefore, Mullahs, 4 of the judges held that mere notice would result in the hiatus in the functioning of the speaker. And Justice Lokur said, how does this question arise? This question doesn't arise in this case. This is all arbiter.
Let us see the,
Yes,
this is together.
This is what I'm just telling you, Lordship, this is the lay of the land as far as the judgment is concerned. Now, let's kindly have a look. Just at the facts at page 1004.
1004.
1017 is
Page 1017.
page 1017. PDF. That's where the justice starts. May I read it?
Justice Care Judgment. Justice Care Judgment.
Justice Kershawar.
100.
PDF 8101.
Yes.
All your lordships have it? The 5th session of the Arunachal Pradesh Legislative Assembly was concluded on 21st of October. On 3rd November 2015, the government an order summoning the 6th session of the Assembly, 15th of January 2016, in the Legislative Assembly chamber at Nagar Lagun. The instant order was passed by the governor on the aid and advice of the chief minister, and in concert with the Speaker of the House. The 6th session of the House was preponed by the governor from 14th of January to 16th of December 2015, by an order dated 9th of December 2015,
So,
indicating...
Sibyl, it's as easy to read a judgment on the digital format as in the paper format.
All right. Yes, yes, I have it. I will be happy to do that. Yeah.
Mr. Solicitor, what's sauce for them is sauce for you also. Huh? We're
Yes,
putting
yes.
you on notice.
No, it's fine, Malad. I'll read it. I've marked
Yes, yes.
Yes. So I said, Malad, the instant order was passed by the governor on the aid and advice of the chief minister in consultation with the speaker of the house. The sixth session of the house was preponed by the governor on 14th January, 16th December, by an order dated 9th December 2015, indicating inter alia the manner in which the proceedings of the house should be conducted. In its support, the governor issued a message on the 9th of December. These actions of the governor, according to the learned senior counsel for the appellants, demonstrate an extraneous and inappropriate exercise of constitutional authority. The above order and message of the governor, without the aid of and advice of the Council of Ministers and the Chief Minister, constitute foundation of the challenge raised by the appellants, as I mentioned to your lordships. When the hearing in these appeals commenced, the impression given out was that the sequence of facts relating to affairs of the House and the MLAs by itself would be sufficient to establish that constitutional responsibilities were exercised in such manner as would be sufficient for this court to strike down the same. The same position was espoused on behalf of the respondents, who also advocated that the factual background would establish the legal and constitutional validity of the governor's actions, and also that the governor has passed the impugned order and issued the impugned message bona fide. The narration of fact, therefore, assumes significance. I just pause here. But in this case, before your lordships, there is no disputed fact. I am not going to argue any disputed. The facts are, the solution will emerge from the facts, as your lordships decide. So, let's leave this out. Now, I don't want to, go further in the matter. Just have a look at the message of the governor, and that your lordships will find.
Over here?
Yes. You kindly see at page 824. This 820. Para 24.
What's the PDF page?
1138.
113.
138.
Yes.
No, one.
1034. 1034.
1034.
I did.
1034. I'll read it from here. So this is Malad's. Your lordships will see here. No, para 21. Don't.
Para 21 is
Learning experience
One.
103.
PDF page 1032.
Malad's para 21. PDF page 1032. That on the same day, sorry,
Para 21.
yes. Need a message.
Yes.
Where I have the speaker. On the same day, 9th of December 2015, Governor issued a message under 175(2), inter alia, fixing the resolution for the removal of the Speaker on the first item of the House agenda at the first sitting of the sixth session. The relevant extract of the same is reproduced hereunder. The resolution for removal of the Speaker shall be the first item on the agenda of the House at the first sitting of the sixth session of the 6th Arunachal Pradesh Legislative Assembly. As the resolution for removal of Speaker shall be the first item of business at the first sitting of the sixth session of the 6th Arunachal Pradesh Assembly, the Deputy Speaker shall preside over the House from the first moment of the first sitting of the House in accordance with the provisions of Article 181 of the Constitution. The proceedings of the House on the leave, discussion and voting on the resolution for removal of the Speaker shall be completed at the first sitting of the session itself. The Deputy Speaker shall conduct the proceedings peacefully and truthfully and shall communicate the results of the voting on the resolution on the same day. The proceedings of the House on the resolution shall be videographed and an authenticated copy of the video recorded shall be sent to me on the same day. Until the session is prorogued, no presiding officer shall alter the party composition of the House. In the meantime, what has happened is, Malaj, and that your lordships will seek, Malaj, that the speaker disqualified 21 people in the meantime. And the deputy speaker, Malaj, with a session outside the precincts of the House, declared that to be void. This is what happened.
So the governor fixed the first item in the agenda as the removal of the speaker.
Yes. And said that you cannot change the composition of the House. In the meantime, it had already been changed because the speaker had already disqualified those 21. It is already changed.
Before 9. Before 9.
Before the 9. That your lordships will see at para 24. Yes. Kindly see. If your lordships have 24. 23, we start from 23. Page 1033 PDF page, Malaj. May I read that one?
Yes.
It was also the case of the appellants that the disqualification proceedings against the 14 legislators of INC, initiated through the notice dated 7/12, were taken up for consideration by the Speaker Nabam Rebia on 14/12. None of the 14 MLAs sought to be disqualified responded to the notice issued to them. They did not even enter appearance before the Speaker on the returnable date, that is 14/12. Accordingly, the Speaker deferred the disqualification proceedings to the following day, 15/12. On 15/12, a disqualification order was passed against all the 14 MLAs. As a natural corollary, the constituencies from which the 14 disqualified MLAs were elected were declared vacant through a notification published in Arunachal Pradesh Gazette on 15th of December. Then 24. It was pointed out, it was the pointed contention of the appellants that on the same day, 15 December, when the aforesaid 14 MLAs belonging to INC were declared disqualified in a purely unprecedented and unconstitutional manner, the Deputy Speaker, Tenzing Norbu Thongdok, quashed the order of disqualification, even though he himself had been unseated through the disqualification order. This is the dance of democracy playing out. Relevant extract of the above order dated 15th December is reproduced below. Order under the 10th schedule to the Constitution of India, whereas the governor of Arunachal Pradesh had issued an order on 9/12 under 174(1) of the Constitution, preponing the session of the 6th Arunachal Pradesh Assembly onto 16/12 from 14/1, whereas the governor of Arunachal Pradesh preponed the 6th session as aforesaid in order to enable the House to expeditiously consider and dispose of a notice of resolution for removal of Shri Nabam Rebia from the office of Speaker, whereas the governor of Arunachal Pradesh had further issued a message to the Arunachal Pradesh Legislative Assembly under Article 175(2) of the Constitution, of which the following part has significance of clipping the abuse of power of the incumbent Speaker. Until the session is prorogued, the presiding officer shall not alter the party composition, whereas the resolution for removal of Speaker Shri Nabam Rebia is listed as the first item of business as the first sitting of the 6th session of the Legislative Assembly on 16/12, whereas the Speaker who is facing the resolution for removal has deliberately refrained from issuing the necessary bulletin part 2 notifying the resolution, and also the list of business on 16/12, including the resolution of transaction by the House, despite the message of the governor and in total defiance of the Constitution, rules, norms, and ideals, thereby subverting the very Constitution of India, whereas the Deputy Speaker who was tasked by the governor to conduct the proceedings of the House on the resolution for removal of the Speaker in accordance with Article 181 of the Constitution of India, read with relevant rules of procedure of the House, prepared the bulletin part 2, the list of business for 16/12, thereby conforming to the Constitution and the mandate issued by the governor of Arunachal Pradesh, where the Speaker, in order to escape the consequence of the resolution of his removal, slated for transaction on 16/12, suddenly a day before the first sitting of the sixth session, on 15/12, disqualified following 14 MLAs by 2 notifications of even number. And then, those names are given, whereas the Speaker has disqualified the above 14 MLAs without the basic procedure of law and justice. Such member to represent his case and to be heard. Whereas when a notice of resolution is staring at the face of the Speaker, he is completely incapacitated from making an order on the membership of other MLAs when his own fate is hanging in balance. Whereas the Speaker, as a constitutional functionary, is not vested with omnipotent powers to cause injury to the powers of the Honorable Governor, who had already issued a message as aforesaid to maintain the integrity of party-wise composition of the House. Whereas the Speaker, in committing this mala fide and perverse action, has not even spared the Deputy Speaker, whom the Governor had appointed to preside over the proceedings of the House when it takes up for consideration the resolution for removal of Speaker. And whereas a Speaker who is facing a removal resolution before the House has no competence whatsoever to pass instantaneous orders under the 10th schedule to manipulate a majority in favor of him, and also a Speaker who has been directed to face the House over the resolution for his own removal has no power whatsoever to escape his defeat by throwing out chunks of MLAs, abusing his powers under the 10th schedule, and whereas the orders of the Speaker disqualifying 14 MLAs, as aforesaid, squarely challenges the position of the Governor, which the Constitution of India had designed him to occupy in the scheme of the Constitution. I, therefore, Malas, Deputy Speaker appointed by the Governor to preside over the first sitting of the sixth session of the Assembly, hereby quash the orders of the Speaker and notification issued by the Secretary of the Legislative Assembly is aforesaid disqualifying above named 14 members of the Legislative Assembly. And such orders and notifications may be deemed as non-est for want of competence on the part of the Speaker who passed the order, not only for not following constitutional and legal procedures, but also for having lost his competence to do so, since a notice of resolution dated 19/11/2015 for his removal is pending against him. It's going to work. And how does the notice to a Speaker, deny him? And look at it another way. There may be several disqualification petitions pending against several political members of several political parties. You may have a disqualification petition against a Samajwadi Party, a BSP person, a Congress person. So a Congress member, one MLA files a notice, he can't even decide the others. He can't deal with the Samajwadi Party or he can't deal with the BSP because he's disqualified.
Let us see those observations in this judgment.
I'm sorry?
Let us see those observations.
Yes.
Like the resolution was passed and the resolution was to be considered for the disqualification of a certain speaker.
No.
See,
in this case, a notice was issued.
No, resolution was also, and it was directed.
Just hear me. A notice was issued, and on the basis of that notice, on the 27th, a writ petition was filed 468 and 469. On the basis of that, it was stated that now that a notice has been issued, the Speaker can't deal with the matter.
Resolution.
True, it was later, the resolution was passed. So, on that basis, and the other thing that happened, two things happened. One, they said that you can't deal with the matter. Two, the Speaker had given only 2 days notice to the MLAs. Second ground raised was that this 2 days is not enough. So these are the two issues raised in writ petition 468 and 469. And on that basis, on the 27th of June, this court said that we give them 12 days, we give them till 12th of July to file their reply. In the meantime, the government was toppled.
Now let us see how they formulated that, what.
I'm just wanted, my Lord asked that question, so I just wanted to respond to that. Yes, I show that, Your Lordships. Now, Your Lordships, see paragraph 188, if I remember correctly.
1131.
1131, I believe.
PDF
1131.
Yes.
PDF 1144.
PDF 1144.
145 is the PDF.
Page, para 181.
181.
Yes. 1142.
185. Okay.
185.
Which one?
Which page?
Right.
Para
Yes, that's right. That's
185, is it?
Yes. Oh, no, 1 second. I'm just give me a minute.
Is it 185?
The discussion starts at 188 minutes. Your Lordship need not really, why it takes too much time. Take 188 straight away. Page 1145. Yes. You've got one. The issue canvassed and answered herein above, with reference to the 10th schedule, does not fully answer the controversy which has arisen for consideration before us. The proposition canvassed also relates to the propriety of the Speaker in conducting proceedings under the 10th schedule, when his own position as a Speaker of the Legislative Assembly is under challenge. After all, this was the real basis of the Governor having passed the attuned order and message dated 9/12/2015. The challenge to the Speaker's position in the incident case was based on a notice of resolution for his removal dated 19/11/2015. The resolution was moved by 13 MLAs, 11 belonging to the BJP and 2 independent MLAs. Despite the above, unmindful of the challenge raised to his own position, the Speaker went on with the disqualification proceedings initiated by the Chief Whip of the Congress Legislative Party on 7/12/2015 by issuing a notice to them on 7/12/2015 itself, seeking their response by 14/12/2015. All the 14 MLAs aforementioned were disqualified by an order passed by the Speaker on 15/12. Under the 10th schedule, was this action of the Speaker justified? The learned counsel for the rival parties pointedly addressed us on this issue. The learned counsel for the we are also of the view that this issue needs to be determined in view of the directions which will eventually emerge on the basis of the consideration recorded herein above. A repeat performance of the earlier process would bring the parties back to the threshold of this court for the redressal of the same dispute which is already before us. In the meantime, the Guwahati High Court actually decided on those issues. When the position of a Speaker is under challenge, now this is where they lay down the law, through a notice of resolution for his removal, it would seem just and appropriate that the Speaker first demonstrates his right to continue as such by winning support of the majority in the state legislature. Now, may I just point out here, they say through a notice of resolution. Actually, this is inaccurate language. It is a notice to move a resolution. It is not a notice of resolution. It is a notice to move a resolution for the removal of the Speaker. Because that resolution is moved only when the House gives leave. So this is completely inaccurate.
Under the proviso.
Yes, yes. So when the position of a Speaker is under challenge through a notice of resolution for his removal, it would seem just and appropriate that the Speaker first demonstrates his right to continue as such by winning support of the majority of the state legislatures. The action of the Speaker in continuing with one or more disqualification petitions under the 10th schedule, whilst a notice of resolution for his removal from the office of the Speaker is pending, would appear to be unfair. If a Speaker truly and rightfully enjoys support of the majority of the MLAs, there would be no difficulty whatsoever to demonstrate the confidence which the members of the state legislature repose in it. Well, just pause here for a minute. Well, if these disqualified members are disqualified, then they would not be in majority. Then this consequence would not happen.
Right.
The office of the Speaker with which the Constitution vests the authority to deal with disqualification petitions against MLAs must surely be a Speaker who enjoys the confidence of the Assembly. After all, disposal of the motion under 179C would take no time at all. Well, I don't understand this statement either. It can take 6 months. If you issue the notice, just after the session is over, and the next session is within 6 months, it takes 6 months. Which means there's a hiatus in the functioning of the constitutional authority. So how did the court say it will take no time at all? It will take no time at all, if the leave is granted in the House and the resolution is put to vote. Then it's no time at all. So my argument before your lordships is going to be the following. Let me state that a notice for removal of the speaker should only be moved when the House is in session. That will prevent, all this malpractice that takes place. It's a proposition, that my learned colleague, Devdutt, suggested to me, and I found it appropriate. Otherwise, what happens is, that you can topple governments at your will, knowing the nature of our politics. But if it is allowed to be moved only when the House is in session, and if leave is granted and within 7 days, it has to be put to vote, then none of this will happen. Then the 10th schedule, will be allowed to function. And also, the speaker, when the resolution is passed, till such time as the resolution is passed, he continues to be a speaker of the House. He only vacates his seat, when the resolution is put to vote.
Otherwise, according to the consequences, the moment a notice of resolution is issued, he becomes disabled.
Yes.
And it's a constitutional office.
Yes, it's a constitutional office. There can be no hiatus. There can be no pause.
That notice has no meaning.
Rules of the legislative assemblies indicate how many members have to move a notice.
29.
29.
20.
All assemblies.
No, they're different. Rajya Sabha is different. Lok Sabha is 50.
29 is the number under the rules.
Yes, under the rules,
Constitution
rules of business.
So then,
It's 10%. 10%.
where does the 10%?
Where do you get that?
Under the rules.
In the
Rule 11 says 29.
Oh,
Rule 11 says
different assemblies will have a different threshold.
Yes, every assembly will have.
every assembly would have a different.
There's no natural,
There's no
uniformity
uniform.
as
No,
such.
no. For example, in Rajya Sabha, in Lok Sabha, it's 50.
Oh, I see.
Rule 20. Rule 20.
The notice can be given by one person.
Which rule is this? Rule number?
Rule 11. Rule 11.
In this.
It is what you're saying. It's rather the whole process, according to your submission, is should be completed in that session.
That's right.
No, the concern rule, you're answering a lot of question. Concern rule is at page 40.
Page
Page 40, statute compilation. My learned friend is right, the figure used is 29, but the logic is 10% because the membership of this house is 288. So the nearest round.
So Rule 11 says 10%.
It is not notice, it is leave to move the resolution. Notice is by one person.
Correct. Unless it is supported by 29 MLAs, correct? It is not a resolution at all.
Yes, not only that, but he may not move it.
And only-
I said, but what has happened in this case, that resolution has never been passed, 8 months have passed. He only did it to ensure that the speaker doesn't pull his act under the 10th schedule. But today, let's talk of this case. That notice was never moved.
No, according to you, notice is never put to vote. Only the resolution is always put to vote.
No, notice may not be moved at all. You may issue a notice, one member, and the one member is common in every assembly rule. In every rules, in all rules of business, of all assemblies in this country, including parliament, one member can move. See the consequence of this. He may move and he may not move it when the session comes up. He may just drop it. Or he may not get leave.
So he may serve the notice even not when the legislature is not in session.
That's right. He may not serve when it's not in session. And see the consequences. And they are doing it in every case now. We also did it in this case. But that's the objection my learned friend took. But when we realized that he was going to disqualify us, kindly see what has happened is, that the speaker has only issued notice to us, that is the Congress, that the MVA, for the disqualification of their members. He has not even issued notice to them on our disqualification till date. And then my learned friend's argument is, go to the speaker and have it decided there. What is going to be decided? He's not even issued notice in our matter.
8 months.
8 months have passed. That's why I said on undisputed facts, violation of the 10th schedule 2.1a and 2.1b is ex facie proof.
So really speaking, there are two thresholds. One is the 14-day notice.
Yes.
When you give the 14-day notice, the House doesn't have to be in session at all.
Yes.
Because it can be even before the House assembles.
Yes.
And once the 14-day notice is given, then Rule 11, which is at page 40 of the statute compilation mandates,
Yes.
that thereafter, not later than within a period of 7 days.
Yeah.
Thereafter, he will request the members who support the notice to rise.
Yes.
And if more than 29 people support it, then leave is granted to move the motion for.
He may still not move it. He may still not move it, It's only leave that's granted.
Right.
So member may not move it.
So, what will happen is, that it will be fixed in the House within 7 days as an item on the agenda, resolution of moving. But this is where the assembly, for the movement of the assembly, how does still such time, the resolution is actually, Speaker is conducting his affairs in the assembly. He is not prohibited either under the Constitution or the rules of business not to sit in that chair, even though there is a motion, there is a notice, and there is leave. He only vacates his chair at the time of voting. So, but as the assembly goes on, but the 10th schedule is paused, constitutionally paused by this judgment.
And it is after leave is granted that the motion has to be then taken up within a period of 7 days.
That's right.
So the first threshold, really, I was just reading Rule 11, says that the motion to remove the speaker is to be given, of which 14 days notice is required under Article 179. That's the Article 179 threshold.
That's correct.
That is given. Then as soon as maybe after the expiry of that 14 days notice period, it would be read to the assembly by the speaker.
Correct.
The speaker said, well, those who are in favor should rise. if 29 people rise, then leave is granted.
Yes.
And then within 7 days thereafter, a motion to
Absolutely.
remove the, that's
the process.
That's the process.
That's the process.
Part of it is constitutional, the 14 days requirement. But the rest of it is legislative assembly procedure. Of course, that's also rules made under the Constitution.
That's correct.
Now, Nebium says that the moment the notice is given by an individual,
Yeah.
you are then disabled. The speaker is disabled from functioning.
As a tribunal, not otherwise in the assembly.
He performs all his
All his functions in the assembly. So how can you have an interpretation of the constitution where the speaker against whom there is a notice for removal functions in the assembly but can't function under the 10th schedule?
So according to you, at what point of time is the disability attached to the speaker?
There is no disability.
There's no disability according to you.
No.
Even after the 29 threshold is crossed and leave is granted to move a resolution, according to you, there is no...
There can't be, mother. Still can't be because the resolution may never be moved.
Unless the resolution is put to motion, put to vote.
Exactly. And mother, the reason is why there cannot be no hiatus. Because mother, there must be somebody in the tribunal to deal with disqualification petition. So you can't say that between the leave and the resolution, he should not function. Because the constitution doesn't allow a pause, brothers, in the functioning of constitutional authorities.
Once leave is granted, Mr. Sibal, the discretion to move the motion is still with the member who is moving the motion.
Yes.
So he may not move the motion at all.
You may not move it.
Is it that after the leave is granted within certain days, the motion is to be moved?
7
actually
days.
put?
7 days.
7 days.
Suppose it is not moved by the concern,
Doesn't matter.
it will lapse.
Absolutely.
But if he stands by his motion, then the speaker has no option but to move it list it within.
Then Article 179, 181 says you must actually move from the chair, become in the, well, then what happens? Very interesting. The
Can we just see, let's keep Nebam. Let's look at the Constitution for a
Yes. 179.
It's always better to apply our
Always
mind.
better. Always better. I agree. I always tell my colleagues, Millet, read the statute before you go to judgment.
That was Justice Frankfurter's great advice, right?
Yes.
There are 3 principles of interpretation. One,
Every time you read the statute of the
the
Constitution,
second, read the statute, and the third, read the statute.
That's right. Something new emerges.
Let's read the...
Yes, I'll read 179. A member holding office as Speaker or Deputy Speaker of an assembly shall vacate his office if he ceases to be a member of the assembly. May at any time by writing under his hand addressed, if such member is the Speaker to the Deputy Speaker, and if such member is the Deputy Speaker to the Speaker, resign his office. And the third C, may be removed from his office by a resolution of the assembly passed by a majority of all the then members of the assembly.
So according to you, really the disability attaches to a removal.
Yes.
And until there is no removal, there is no disability. There is no Constitution does not contemplate a hybrid situation.
Either as a Speaker of the assembly or under the
Member.
10th.
Or under the 10th schedule.
In the proviso.
Yes.
Provided.
Provided that no resolution for the purpose of clause C shall be moved unless at least 14 days notice has been given of the intention to move the resolution. Provided further that whenever the assembly is dissolved, the speaker shall not vacate his office. That's we are not
First
concerned.
proviso.
Now kindly see 181. But the second proviso was also important because the speaker is a continuing. Shall not vacate his office until immediately before the first meeting of the assembly. Shows no pause, as I said.
So this, at least 14 days notice of the resolution is given is now regulated by the rules of procedure, which says first 14 days of the notice.
Yes.
Then the leave is to be granted.
Right.
And thereafter 7 days, a period of not more than 7.
But some problem may arise. For example, nowadays, we see diminishing meetings of sessions in Parliament and in the assemblies. Budget session sometimes in some state assemblies is only 5 days. And only 7 days. So where do you get the 14-day notice? That's the other problem. We have to look at it, the ground realities, The Constitution says 14 days notice because the Constitution makers never imagined that we will make the assemblies redundant by not meeting at all. But the whole process has been polluted now. We never thought. I'm not saying now. Look, I make no political arguments in court. I've said all governments. Remember, I made all those views. So there's no politics in this. See, this is for the country, for democracy. This is not for A or B. We come to power, some other party comes to power, they'll misuse it. They'll misuse it to your disadvantage. So let's not get into that.
Read 181.
In this case, even the 11th position has not reached, is your argument.
Yes, yes. And this is what is happening, Maharaj. So you won't get the 14-day notice. So then how will you remove him? Now, if you have the 14 days notice, even if it is earlier, Maharaj, then you can't say he's disqualified.
Second proviso, it's a very
Yes.
interesting proviso.
Yes.
Provided further that whenever the assembly is dissolved, the speaker shall not vacate his office until immediately before the first meeting of the assembly after the
Correct.
dissolution.
That's correct. It's a continuing. It's a continuum.
Speaker continues notwithstanding the fact that he was elected through the assembly
That's correct.
until the new assembly takes
Even in dissolution.
even in dissolution.
Then what happens is that the speaker vacates his office in the next session when it is reconvenes, Maharaj.
The pro tem speaker.
And then the pro tem speaker, the oldest member of the house normally, is then presided over them.
This was relied on by Venkatachalaya to uphold the position of a speaker, saying that he has got nothing to do with the political party, his objectivity is there, despite the house speaker continues. So therefore, we can trust the speaker as the arbiter. That's
Whereas we've seen that trust, Maharaj, we've seen that trust being used and misused.
Gulzari Lal Nanda.
the argument was rejected in your.
Mr. Nariman and my argument was this is unconstitutional. Don't give it to the speaker. But Maharaj, it was rejected.
It was
by
rejected.
3-2. But I think the time has come in your Lord. I really think so, Maharaj, because this is not about this case alone. These are quintessential questions which will, on the basis of which democracy will survive. Otherwise,
Then give it to the speaker, then who will decide?
the court.
Why should the court?
It's a matter for the house. That's
I know.
that
That's-
argument was also
That
rejected.
is exactly what Justice Sabharwal says in
Was
Jagmeet.
that we court should not, because it was argued saying that court can't get into the house to decide.
And
whether-
ultimately, if you say that this is unconstitutional, then you completely throw the baby out with the bathwater.
Yeah, but-
There's no disqualification.
Well, there is no bathwater left at the moment, Maharaj.
It's an
But
endeavor of
well, otherwise, if you say that, well, the entirety of it goes, then there's no provision for disqualification.
That parliament will have to make one. That's the parliament wants to deal with morality in politics, they will have to make this. This has to be done. Now, how it make it, what is the contours of that
You don't have
legislation?
to go to the extreme of, yeah.
No, I'm not. I'm only saying, Maharaj, I'm only saying to your lordships that this is the,
Nabam ka theek hai.
Well, let's draw a line there, Mr. Sibal, or else it will become unending.
It will become,
It will become unending.
and there has to be some constitutional certainty also. I mean,
no, but then you must lay down a law, Maharaj, that there is some certainty, because otherwise, Maharaj, what is happening is, Maharaj, that these matters are never heard. Your lordship knows adjournments are granted every week, Maharaj, for years. For years, these matters are not heard because the speaker is sitting there. And we come to court and the court doesn't.
But therefore, your argument on Nabam really is that the constitutional scheme does not contemplate the disqualification of the speaker merely on the issuance of a notice, or for that matter, even upon the grant of leave according.
That's right. That's right.
181.
81.
Yes, 181. At any sitting of the Legislative Assembly, while any resolution for the removal of the speaker from his office is under consideration, the speaker, or while any resolution for the removal of the deputy speaker from his office is under consideration, the deputy speaker shall not, though he is present, preside, and the provisions of clause 2 of the article 180 shall apply in relation to every such sitting as they apply in relation to a sitting from which the speaker, or as the case may be, the deputy speaker is absent. The speaker shall have the right to speak in and otherwise to take part in the proceedings of the Legislative Assembly, while any resolution for his removal from office is under consideration in the Assembly, and shall, notwithstanding anything in Article 189, be entitled to vote only in the first instance on such resolution or on any other matter during such proceedings, but not in the case of an equality of votes. 189 says that if there is equality of votes, then the casting vote is with the Speaker. But when his resolution for his removal is in consideration, he can only vote
Now,
in the
where
first
do the
instance.
words, how do the words, when do the words under consideration kick in?
Kick in at the time when the motion is moved for consideration.
Is that so, or does it kicks in the moment leave is granted to move a resolution by 29
No. But the resolution may not be moved, as I said. No.
Still remains under consideration.
Yeah, because then he can't be the Speaker, Manoj. Then how can he sit on that chair?
And how can
No, he can't be the speaker in the meeting, correct? Or the day on which the actual resolution is
Yes.
taken into consideration.
Yes.
Taken up for consideration.
Absolutely.
That is what you're submitting.
That's right.
otherwise under Rule 11 he cannot act?
Because otherwise he can't act, grant leave. He has to be
Clause
granted by him.
2, interestingly, both clause 2 and clause 1
Yes.
use the expression under consideration.
Yes.
Now, conceivably, the word under consideration in clause 1, words under consideration in clause 1 may not only be relatable to the date on which the resolution is taken up for consideration in clause 1. But in clause 2, it is obvious that the words under consideration operate on the date when it is actually taken up for debate.
That's right.
So the question is whether we should therefore expand clause 1 and say that under consideration in clause 2 relates to a different point of time than in clause 1. That's a possibility.
Well, it's my respectful.
According to you, it should be the same.
I'll tell your lordships why. The word consideration is not a word of art in clause 1. It is a word which relates to the procedure of the House. It's not a word of art.
Because
Under
two
consideration-
says that you have a right, he has a right to speak when it is under consideration.
Yes.
Now, his right to speak is on the motion when it is.
That's
taken.
correct. That's correct.
Therefore, according to under 1, where he is not entitled to preside, this will attach on the date when the motion is taken.
The reason is, Manas, the word consideration is used in the context of procedure when his removal is being considered.
So according to you, therefore, even when leave is granted, in the stage of the threshold of leave is crossed, even then he can really preside.
Allahabad judgment.
There's a judgment, Manas, of the Allahabad High Court to that effect, which I showed to your lordship.
The word sitting.
It goes with the word sitting, Manas, my lord.
Is this scheme of 179 and 181 any manner affected by the 10th schedule?
No. This is our case, Manas. It can never be. These are proceedings in the House. These are legislative proceedings in the House.
The 10th schedule is silent on what happens when there is a notice.
It can't, Manas. In fact, the 10th schedule, there can be no pause, Manas, because it's a constitutional authority.
In fact, under
There can be no higher, as I said, Manas, that's the base. It's a fundamental principle of constitutional law. Whether it's the Election Commission, the government, the Speaker, Manas, the courts, there can never be a pause. It's anathema to
180
constitutional.
relating to the presiding officer of the tribunal's competency.
Yeah.
They only relate to those two.
Yeah.
So 10th schedule to that extent will have no bearing.
Doesn't apply. Because it's in the House. We're talking about his removal from
About
the
the
House.
presiding officer. It's about his.
The flip side, if we permit a speaker, now you're assisting the court as counsel,
Yes,
not really.
Yes, of course.
Because we are looking now at a broader constitutional issue. What would be the consequence if we allow a speaker to participate? There are two stages, right? One, just the notice. The notice is, of course, it can be given even by one person. What would be the consequence if we don't allow the speaker to take action the moment a notice of resolution is issued? That, according to you, would result in a very serious consequence. But on the flip side, what would be the consequence if we allow the speaker to participate even when the stage of, say, the grant of leave is crossed? What would be the argument on the flip side?
No, Manas, there have to be 29 members have to support that. He cannot decide.
No, 29 persons MLAs have already supported and the leave is granted.
If they've supported, Manas, and leave is granted,
Correct.
then, Manas, the day
Mr.
What Chief is-
my
What
learned
Peter-
brother will explain what was falling.
was asking you is, what will be the consequence of the speaker continuing to decide the 10th schedule proceedings while a proceeding is pending after issuance of the notice?
As I said, as I said.
That's the question.
Yes, as I said,
Other line of, it should be seen in the context of other line of judgments on the 10th schedule, saying why is he in such a hurry to decide? There must be sufficient time.
let me, Milad, answer that straight away, Milad. Now, you are interpreting 179 to mean that the speaker will continue to discharge his functions as a speaker till the motion for his removal is put to vote. The purpose of
Correct.
Correct, Milad? He has no disability. Correct? And till it is put to vote, the motion may never be moved. May never be moved, Milad.
So,
Mr. Sybil, what is worrying me, of course, is sorry, Nasma.
No, go ahead.
What is worrying on the other hand is this. He's just putting it to you. On the other hand, if you say that, well, he can take all action, including on deciding on disqualification, until the motion is put to vote, the day he's put to vote, the consequence then may also be this, that he can affect the motion for his own removal by deciding upon the disqualification.
I tell you, Lordship,
That's so desirable.
No, that I tell you, Lordship,
That
there's a difference there. There's a difference there. Mullah's, his removal by the House is not subject matter of challenge. The legislative process. Internal to the House. A disqualification in the same schedule, subject matter of challenge. Judicial.
Person is wrongly disqualified.
Person is wrongly disqualified, your Lordship have so often intervened. Set it aside, you can go back.
But of course, therefore, then we'll also have to factor in. The sense of your submission is that though a speaker then can, by deciding upon the disqualification issue, essentially affect the course of his own removal.
No, well, that is your Lordship is assuming that he will discharge his functions in a malified manner. That's your Lordship will have to make that constitutional assumption. And the whole purpose of Geruto Holohorn.
Ultimately, that was the whole basis of your initial submission.
No,
Support who will.
because I am being an arbiter in these matters at all. But that's another matter. That's nothing to do with it.
The only thing which seems to have reached the court is that's really, otherwise constitutionally your argument is, I mean, obviously, prima facie, your argument on reading 179 and 181 are very clear. But now the only point is this, that by giving the power to a speaker, are we then going to essentially give the speaker the ultimate power to decide upon the course of his own removal?
No, it's not the course of his own removal, it's the course of the removal of those who have actually voluntarily given up membership of the party. This is not a question of course of his own removal.
Yeah, that's
Because he belongs
You tilt the balance.
I'm sorry?
That may tilt the balance.
But it will, if they have voluntarily given up, it will tilt the balance. Why should it not tilt the balance? Why should it not tilt the balance? If actually, but kindly forget about, well, now let's go into just a short summary of facts. In this case, what happens? In this case, what happens is this notice is given. This court says they can reply by 12th of July.
right.
And the government falls in the meantime. And we are 8 months down the road. He has not even given notice on our disqualification petitions. No, the person has not moved the notice and the speaker has not given a notice on disqualification petitions. I mean, you have seen the
So according to you, the speaker was well within his right to disqualify anybody in the meantime as well.
because of the facts which are undisputed. You had a new government with the support of these people. What else is it but voluntarily giving up membership of the party? And then, Manoj, if the argument is he is going to decide his own fate, no.
Now, Mr. Sybil, we saw the first part of Nabam Rebia where Justice Keir puts it as a matter of ethical grounds. Now, how does he interpret?
Yes, I was going to read that.
Well, let's just read
We'll go that. We'll go
So
further.
that's the next step
Yes.
to cross on Nabam.
Yes, absolutely.
I didn't want to interrupt the speaker when they said that the fresh disqualification notices after the new speaker took over were not issued for 8 months, because during that hearing in the Supreme Court, everyone decided that while your lordship are seized of the matter, the speaker would not precipitate the matters or proceed further. So to say that he did not act on those notices is completely incorrect, because that was something which was agreed to by the parties. What was not agreed to by the parties was EC being injuncted, which your lordship decided. But the other issue was, when we all were here, we all were ad idem on the fact, let it not be precipitated. It's a very wrong impression being given as if the speaker has been sitting and not even issued notices after that.
Because he issued notices against us. He said, we should notice again, despite what my learned friend is saying. So what's the point of this kind of interjection? He selectively issued notices. There was no bar as far as he is concerned to issue notice to us. But there's a bar as far as notice to their own people. What kind of intervention is that?
To both the
Anyway, one second.
both parties.
One
All
second.
right. Now let's, Mr. Sibal, for a moment, you're not clouding our mind on the correctness of Nabam, on the facts of this case. That
Yes.
would be a very improper. We must
Yes.
look at it straight on as a constitutional inquiry.
Yes, I agree, Malaj. I'm only saying, yes, absolutely. If you're, Malaj, the point is there are two. Malaj, later, Malaj, they are also interpreting the word then members of the assembly.
Yes.
And you will have to look at that. Malaj.
Let's see that now.
Yeah.
Para 190 and
190, Malaj, let's read that first.
That's the only ground of.
Yes, that's the only ground. Which is also, according to me, constitutionally erroneous, but we'll argue that later. Just like the other provisions of the Constitution interpreted by us here in above, it would be apposite to ascertain the desired intent of the framers of the Constitution emerging from the Constituent Assembly debates with reference, I'm sorry, your lordship has that?
yes.
Para 190. With reference to Article 179C. In the draft Constitution, the present Article 179 was numbered as draft Article 158. One of the issues debated with reference to draft Article 158 small c was with reference to the words, quote, all the then members of the Assembly, unquote, used therein. The above words were used to define those who would participate in the motion for the removal of the Speaker. Needless to mention that the said words were retained in the final draft in Article 179C. One of the members of the Constituent Assembly had suggested substitution of the above words by the words, the members of the Assembly present and voting, as under CAD volume whatever. Muhammad Tahir, sir, I beg to move that in clause C of Article 158, for the words all the then members of the Assembly, the word the members of the Assembly present and voting be substituted. In other words, the majority not be counted in the context of all the members of the Assembly, but only those who are present and voting. There, sir, as far as I can understand, the meaning of the wording, all the then members of the Assembly, it includes all the members of the Assembly. Supposing a house is composed of 300 members, then it will mean all the members of the Assembly, that is 300. Supposing 50 members of the House are not present, then those members will not have the right to give their votes as far as this question is concerned. Therefore, I think it would be better that this matter should be considered by only those members who are present in the Assembly and who can vote in the matter. In this phrase, all the then members of the Assembly means the members who are present in the Assembly. Then, I have no objection. If it means all the members of which the House is composed, I think it is not desirable to keep the clause as it stands. With these few words, I move my amendment. The Constituent Assembly debates do not appear to have recorded any discussion on the above amendment. The decision on the proposed amendment was, however, minuted under so-and-so. Mr. President, the question is that in Clause C of Article 158, for the words all the then members of the Assembly, the words the members of the Assembly present and voting be substituted. It is apparent that the Constituent Assembly chose to retain the words all the then members of the Assembly and declined to substitute them with the words the members of the Assembly present and voting. We are of the view that the acceptance of one set of words and the rejection of the suggested substitution would effectively render a constitutional answer to the issue. Article 179C provides that a speaker or deputy speaker may be removed from his office by a resolution of the Assembly passed by a majority of all the then members of the Assembly. A notice of resolution for the removal of the speaker or the deputy speaker of the Assembly would therefore have to be passed by a majority of all the then members of the Assembly. The words all the then members included in Article 179C are a conscious adage. If the words all the then members were excluded, then Clause C of Article 179, it would have that.
This really means that all members of the assembly mean
That's right.
that you have to meet a higher threshold.
Correct. That's
So
like
if
in
you
the
have
judges' removal, Bharat.
If you have a 300, have a motion for removal passed, you must have 151.
That's right.
But what it means is that instead of 300, you have say 90 present that day, and people are not well.
Still 151 will have to.
Still 151.
Absolutely.
50% of 190.
Correct.
So the threshold required is given the strength of your assembly.
That's right.
All that
This is the constitutional logic, Mother, that they have used.
they say that, well, because the constitutional provision says all the members of the, that means that the speaker has no power to decide upon the disqualification of only, not according to the secretary.
Doesn't seem to be constitutionally
And
logical. Whereas, for example, when a judge is removed,
because you can't compel a member to attend.
Yes, yes.
So somebody is down
Well,
with a serious medical issue.
no, not only
It
that,
doesn't require a disqualification.
not only that, how do you bring back a man who has died?
As of that date. That's
You can't bring him
Would be a
back.
vacancy.
Then members he is frozen. Unfortunately, you can't bring him back. No matter how we think. So you can't bring him. A man who resigns. How can you prevent a resignation? Freeze on the date of the notice. You can't freeze the numbers of the House. So completely.
Read further, Mr.
Yes, I'll read further. So Mother's,
This is, I think, the only paragraph.
then members excluded from clause C, it would affirm the interpretation of the appellant. The connotation placed by the appellant would legitimize the action of the speaker in going ahead with the proceedings under the 10th schedule, even though notice of residence was pending. The words all the then members consciously added in 179, and this substitution was not accepted by the Constituent Assembly. We are satisfied with the words passed by the majority of all the then members of the Assembly would prohibit the Speaker from going ahead with the disqualification proceedings under the 10th schedule, as the same would negate the effect of the words all after the disqualification of one or more MLAs from the House. the words all the then members demonstrate an expression of definiteness. Any change in the strength and composition of the Assembly by disqualifying sitting MLAs for the period during which the notice of resignation of the Speaker or Deputy Speaker is pending would conflict with the express mandate of 79C, requiring all the then members to determine the right of the Speaker to continue. It would also be relevant to notice that the 10th schedule was inserted in the Constitution by the Constitutional 73rd Amendment, Act 1992, with effect from 1990. Well, this is also wrong. It is by the 52nd Amendment, not the 73rd, introduced in 1985, not 1993. This is also somehow error is.
Next para. No, next.
The purpose sought to be achieved through the 10th schedule is clear and unambiguous. The same is unrelated to and distinct from the purpose sought to be achieved through Article 179C. Neither of the above provisions can be seen as conflicting with the other. Both must therefore freely operate within their individual constitutional space. Each of them will have to be interpreted in a manner that would serve the object sought to be achieved, without spreading into the constitutional expanse of the other. The interpretation would have to be such as would maintain constitutional purpose and harmony. We would now venture to examine the present issue, the above perspective in the following. Now, if this is right, if
193 also. Next para also is.
Yes. If the Speaker survives the vote on the motion for his removal from the office of the Speaker, he would still be able to adjudicate upon the disqualification petitions filed under the 10th schedule. The process of judicial review cannot alter the above position. But if a disqualification petition is accepted by the Speaker, the disqualified MLAs will have no right to participate in the motion moved against the Speaker under 179C. A disqualified MLA, as we all know, can assail the order of his disqualification by way of judicial review, which is what I was saying, Millers. If he succeeds and his disqualification from the House is set aside, such a disqualified MLA would be deprived of the opportunity to participate in the motion of the Speaker under 179C. In this situation, the process of judicial review can also alter the position if a disqualification order passed by the Speaker is set aside by a court of competent jurisdiction. In the event of an MLA having been disqualified by the Speaker, the notice of resolution for the removal of the Speaker would surely be dealt with and will be disposed of during the period when the MLA concerned was disqualified. Alternatively, if an MLA has not been disqualified, when the motion for removal of Speaker is taken up, he would have the right to vote on the motion pertaining to the removal of the Speaker, whereafter the petition for his own disqualification would certainly be considered and decided by the Speaker. It is apparent that the difficulty arises only if the disqualification petition is taken up first and the motion for removal of the Speaker is taken up thereafter. That is where that comes from. The possibility of a disqualification petition being decided on political considerations rather than on merits cannot be ignored. This works both ways. It doesn't work one way. In fact, that is a real possibility. Therefore, while it will not adversely affect the Speaker if he faces the motion of his own removal from the office of the Speaker before dealing with the disqualification petitions, it could seriously prejudice MLAs facing disqualification if petitions for their disqualification are taken up and dealt with first. The adoption of the former course would also result in meaningfully giving effect to the words all the then members.
So everything comes down to all the then members.
That's correct. That's correct.
The last three lines also.
Members used in the Article 179C, as discussed in the foregoing paragraph. This interpretation would also purposefully give effect to the rejection of the amendment suggested during the Constituent Assembly debates that the motion for removal of the Speaker should be the majority of the members of the House present and voting. This interpretation would also result in disregarding the retention of the words all the then members of the Assembly in Article 179C. If the Speaker faces the motion of his own removal first, both the constitutional provisions would have their independent operational space preserved. None of the constitutional provisions concerned would interfere with the free functionality of the other, nor would one usurp the scheme postulated for the other. We're therefore of the view that constitutional purpose and constitutional harmony would be maintained and preserved if a Speaker refrains from adjudication of a petition for disqualification under the 10th schedule, whilst his own position as the Speaker is under challenge. This would also allow the two provisions, 179C and the 10th schedule, to operate in their individual constitutional space without encroaching on the other. For the reasons recorded above, we hereby hold that it would be constitutionally impermissible for the Speaker to educate upon disqualification petitions under the 10th schedule, while a notice of resolution for his own removal from the office of the Speaker is pending.
That's one.
And Millet, we have in our note, and I will show that to your lordships presently, there are other provisions in the Constitution where the expression then members is used.
Actually, this,
And Millet, that has been interpreted. Sorry.
no, actually, as Madan Lokur's judgment says,
I can't hear you.
as Justice Madan Lokur's judgment says, this was not necessary also to
Exactly,
decide.
exactly. It was not
Because it was
necessary for
the-
the case. I don't know why the judges went into it, because Justice Mishra, I was in that matter, raised this issue on his own and said we must also look at it.
Really, 9th December 15th decision of the governor was the real.
That's correct. That's set out in the first paragraph of the judgment itself. It's really all arbiter. It's really not.
Very preponed the
Yes.
meeting.
Preponed and sent a message saying how you will consider. So both the message was struck down and the preponing of the session was struck. That's what really happened.
Of
This
course,
really
the
was.
subsequent decision of the deputy speaker reversing the speaker's order.
That's right. And declaring
That
that
was
to be
another.
void. That also. But the disqualification matter then went to the Guwahati High Court, and there they were decided one way or the other.
Initially, Laddha Singh stayed the entire proceedings.
Correct. So the issue is simple. Assuming, and let's put it, your lordship was Miller's putting to me that you are also concerned with the other aspect as to why he should be allowed to continue. Let's assume he is not allowed to continue. But who will then decide under the 10th schedule? The petitions are pending, no?
But on facts of the present case, is it because of the principle in Nabam Rebia that the problem has arisen for you, or is it just that the judgment is wrongly decided? Refer to the last application on your case.
The implication is very serious because on 27th, because of these
Give us
two
the
arguments.
What are the dates of your?
I'll just tell you, lordship, brief the order. On the 27th, when this was passed, the order saying, give them till 12th of July. Until 12th of July. Then, Maharaj, obviously, these people were legitimately members of the assembly. So then they, Maharaj, went to the other side, and the new chief minister was sworn. Maharaj, in fact, an elected government was toppled through this procedure.
Right. Now let's see how Justice Mishra deals with
Yes, Justice Mishra also.
Yeah.
Yes,
and then Justice Malik.
that's correct. One one four two.
4-6.
1146. Maharaj.
This is Narasimha's theory, the foundation of the import order in this case, when it's got is Nabam Rebia, is mentioned. And thereafter, the entire notice disabling is based on that.
See.
Foundation is that.
1142.
46. Yes.
No, PDF. Tell us.
115 PDF, 1146 will be there.
Mishra.
Yes.
What is the para number?
Yeah. Sorry.
Just
Sorry.
Mishra.
Yes.
Are you referring to Justice
Yes.
Mishra's concurrence?
Yes.
Okay. Para 216. Shall I say 215?
He quotes Article 179.
Yes, 215.
And then at 218, Mullahs, he starts discussing, if I may read that.
115 PDF.
The thrust of the matter. Para. The 217, Mullahs, the learned judge quotes 179.
Yes.
The thrust of the matter, if your lordships have it, I'll. Thrust of the matter is what interpretation is to be placed on Article 179C and the first proviso, being diligently and respectfully adherent to the norms of constitutional interpretation. I may state with quite promptitude, purpose of adherence should not convey that one can find any kind of static principle. Principles that flow from our organic by text and passionate constitution. Passionate is a very warm politics is always lack of constitution. Anyway, there are presidential guides, and if I allow myself to say constitutional precepts, to serve as a light posts without causing any violence, even remotely, to the language employed. Then Malaji quotes Karnataka. Let's your Lordship want me to read, I will read, but I don't think it's.
No.
In verse 220, the aforesaid paragraphs clearly convey that judicial interpretation cannot nullify, defeat, or distort the constitutional provision of the interpretive process cannot, in direct conflict with the express provision of the Constitution. However, the learned Chief Justice has observed that constitutional document has to be read as a whole and construed keeping in view the declared objects and functions. In the said judgment, a distinction has been drawn between constitutional law, the fundamental law, the laws which may be important constitutional matters. I think it appropriate to reproduce. When those passages are reproduced, it's para 223, with giving the Constitution a purposive interpretation, and it just relies on all those judgments. Then 223 paragraph. I have referred to the aforesaid pronouncement as they have laid down the guidelines for the text, context, the words and the purpose of a constitution. Emphasis is on flexibility, adaptability, and durability, and also not to import or implant an interpretation which would be in conflict with the express language of the Constitution. Having received the guidance from the precedents and keeping in view the cohesive constitutional precepts, I shall proceed to analyze the language of 179C. Prior to that, I think it convenient to dwell upon the importance of the office of the Speaker. There is no shadow of doubt in my mind that to appreciate the significance of the provision, namely 179C, in the context of constitutional supremacy and constitutional consciousness, it is necessary to understand the position of the Speaker. The Constitution. Office of the Speaker in our history had its origin in 1921, and the Legislative Assembly was constituted. Mategu Road reform. That time, Office of the Speaker did not enjoy much importance, but a significant one after the Constitution came into force, as is evident from the constitutional scheme of ours. The Speaker enjoys high constitutional status, and the Constitution reposes immense faith in him. For this reason alone, the Speaker is expected to have a sense of elevated independence, impeccable objectivity, and irreproachable fairness, and above all, absolute impartiality. This expectation is a constitutional warrant, not a fond hope, an expectation of any individual or group. The Speaker has the duty to see the business of the House is carried out in a decorous and disciplined manner. The functioning requires him to have unimpeachable faith in the intrinsic marrows of the Constitution. Constitutionalism and rule of law, the faith, needless to emphasize, should be visible and apparent. That is why possibly former Speaker of the House of Commons in the UK, Baroness Boothroyd, when you have been committed all your adult life to ideals and policies of one party, impartiality is a quality that you have to work at. But if you cannot put aside partisanship, you have no right to even think of becoming the Speaker. I have referred to the aforesaid only to stress upon the impartial functioning of and constitutional neutrality of the Speaker. The expression can be different. One wishes to choose the ancients. The ancient wisdom would require the Speaker to abandon his Ram and get wedded to Parashram. To elucidate, a Speaker has to constantly remain in company with the cherished values of incarnation of his office and not deviate even slightly from the constitutional conscience and philosophy.
Actually, para 233 and 235.
That's right.
233 is the real para.
Notice how far removed are these words from reality is something that we can take notice of. 233. 233, Malak?
Yes.
There can be myriad situations of democracy. The Constitution, as an organic instrument, has to be interpreted to meet all exigencies. It has to have the resolution for removal of the Speaker, the office immediate Speaker, on a complaint initiates action under the schedule. As the resolution against the Speaker cannot be moved unless 14 days expires. Notice period expires. The members can be disqualified within the said period, and the Speaker would gain an advantage. Thus, it can result in a situation of conflict, that is, conflict between the status of a Speaker conferred by the Constitution, the position he has been after the constitutional amendment. The final arbiter have trusted him regard being had to his constitutional status. It is the constitutional trust, therefore, there should be perceptibility of absence of conflict. That apart, it will not be in harmony with Article 179C or the constitutional norm. It would also cause discord with the language employed in the said article. The founding fathers had deliberately retained the words all the then members by negativing the proposed amendment. The purpose of not accepting the amendment is to preserve the constitutional control over the situation. In this regard, I may usefully refer to 189 of the Constitution. It provides for voting in houses, power of houses to act notwithstanding vacancies in quorum. Clause 1 of Article 189 stipulates that, save as otherwise provided in the Constitution, all questions at any sitting of a House of the legislature of a state shall be determined by a majority of the votes of the members present and voting, other than the Speaker or Chairman or person acting as such. The said clause also provides that Speaker or Chairman or person acting as such shall not vote in the first instance, but shall have the exercise of a casting vote in the case of equality of votes. The said clause thus clearly states that the majority of votes of the members present and voting, and secondly, it empowers the Speaker to exercise his power of voting in case of equality of votes. In contradistinction to the same, 181 provides that the Speaker or the Deputy Speaker is not to preside while resolution for his removal from office is under consideration, and he is entitled to vote in the first instance on such resolution, but not in the case of an equality of votes. Article 181(2), which is relevant for the present purpose, reads as follows. We've read that. The purpose of referring to the said article is to highlight the nature of participation of the Speaker when the question of his removal arises. It is clearly different. Under the Constitution, he is entitled to take part in the proceedings and speak. Therefore, he is in a position to contest. Appreciating the scheme of the Constitution, especially keeping in view the language employed in the first proviso to Article 179C, it is quite clear that it is the constitutional design that the Speaker should not do any act in furtherance of his interest till the resolution is moved. In this regard, it is essential to understand the character of the 10th schedule. The 10th schedule to the Constitution has conferred adjudicatory powers to the Speaker while deliberating on the constitutionality of the said schedule. The majority in so and so has stated and follows. Glosses may leave that, we know. Then verse 237. The aforesaid reasoning eloquently speaks of the power, position, and status of the office of the Speaker enjoys under the Constitution. It also states that the scope of the fiction, the court has constricted the power of judicial review restricted, each carving out certain extreme exceptions. It is because the Speaker, while exercising the authority, jurisdiction exercises the power of constitutional adjudication. The concept of constitutional adjudication has constitutional value in a parliamentary democracy, and constitutional value sustains democracy in a sovereign republic. The Speaker is expected to maintain propriety with an adjudicator. The Speaker, when functions as the tribunal, has the jurisdictional authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, such impartiality should be perceptible, be beyond any reproach. It must reflect the trust reposed in him under the Constitution. Therefore, the power which flows from the introduction of the 10th schedule by constitutional amendment is required to be harmoniously understood in 79. Provisions of the Constitution are meant to subserve the purpose of sustenance of the basic feature of the Constitution. Speaking about democracy in India as a product of the rule of law is only a political philosophy, also an embodiment of constitutional philosophy. Thus, regard being had to the language of 179C and the role ascribed to the Speaker, it is necessary that the Speaker of the tribunal have complete and procedural. When there is an expression of intention to put the resolution removed, it is requisite and then proceed. That is the intent of 179C. Said interpretation served the litmus test of sustained democracy founded on the rule of law. Founding fathers had so intended, and the constitutional value, trust, and morality unequivocally so suggest. It would be an anathema to the concept of constitutional adjudication if the Speaker is allowed to initiate proceedings under the schedule. After intention to remove him is removed. 14 days period being mandatory, the words all the then members gain more significance. The Constitution has confidence in the Speaker. I would like to call it repose of constitutional confidence. Simultaneously, the command have the confidence of the majority of the actual or real figure. This understanding is gatherable from the express provisions of the Constitution. clearly brings in harmony between constitutional confidence or trust and the constitutional control. It is stated the position has to remain the same even after introduction of the 10th schedule to sustain the robust vitality of our growing constitution. It embraces the seminal spirit of the rule of law that controls all the powers, even the prerogative power. Before parting, I that the constitutional restraint and discipline are revealed from the words of the Constitution, and the high constitutional functionary who should remain indebted to the with humility, because it is humility that forms the foundation of regard, which is the ultimate constitutional virtue. Nonetheless, all that the learned judge has said is contrary to judgment after judgment by this court, saying just the contrary. That we have seen speakers behaving in a particular fashion. We have seen the manner in which they have conducted themselves. Actually, it is Parliament who must change this system. I'll give those judgments to your lordships.
Now, just let's see Justice Lokur. So,
Yes, Justice
actually,
Lokur.
Justice Mishra again refers to the words of all the members, all the then members of the.
That's again the same thing.
He also places it on the ground that there must be an impartiality of the speaker. So the moment there's an expression of an intent to remove him or them, he should first stand the test. So the moment, in fact, that means that Justice Mishra even goes as far as to say that the moment a notice is given, the initial notice, because he felt that otherwise what will happen is within the 14-day period for the notice, the speaker would remove these people, disqualify them.
That's right.
And that would affect the impartiality of the speaker. He places it on the ground of constitutional trust.
More than the interpretation, he is on the ground that impartiality of the speaker.
Because within that
he should
14-day
stand
period, if the speaker is allowed to disqualify, that would affect his own impartiality. Because as an arbiter under the 10th schedule, he has to be impartial. That's what that's the constitutional theory with Justice Deepak Mishra.
Well, it's like saying, if I'm holding a constitutional office, then there's an expectation that I will be impartial. Now, the underlying this is the expectation that he will not be. That's the underlying theme of Justice Mishra.
What does Justice Lokur say? Let's see the
Yes.
Lokur.
242.
4042.
401.
4242.
PDF 1224.
1224 PDF, paragraph 401.
To navigate. One.
No, para 396, I think.
Yeah, 396.
396.
Question here. 396. My Lord Justice Shah.
Chief,
Which one?
23. 1223 PDF.
1223. Yes.
The question here is not whether the disqualification of 14 members of the Assembly is valid or not. That was a matter pending consideration in the Guwahati High Court, when the judgment in these appeals was reserved, but has since been decided. We're not concerned with the decision of the Guwahati High Court or the power or propriety of the decision of the Speaker. The narrow question is whether the Deputy Speaker could, by his order dated 1512, set aside the order of the Speaker, also dated 1512, disqualifying 14 members of the Assembly, including the Deputy Speaker. The Speaker gave notice to the 14 members of the Assembly on 7/12, them to show cause why they should not be disqualified. Under the 10th schedule, thereafter, by an order dated 1512, Speaker disqualified them from their membership in this Assembly. As mentioned above, the correctness of this order and the procedure followed has now been decided by the Guwahati High Court, and the correctness of that decision is not before us. Speaker passed an order of 1512 inter alia on the ground that the Speaker lacked the competence to pass the disqualification order and that he had not followed the constitutional and legal procedure of his removal. He had lost his competence to pass the disqualification order since a notice of removal dated 1911 was pending. He was to come up before the Legislative Assembly on 1612. In passing his order on 1512, the Deputy Speaker purported to drive his power from the message given by the Governor to the Legislative Assembly, requiring the Deputy Speaker to conduct the procedure of the House on the resolution for removal of Speaker. What is important to note is that the Deputy Speaker was to preside over the House on 1612. He certainly had no derivative power from the Governor dated 9/12 to take over the functions or to sit in judgment over the decision of the Speaker. That apart is now well settled by the decision in Kyoto that the Speaker, while acting under the 10th schedule, acts as a tribunal and his decision can be challenged only in a court exercising constitutional jurisdiction. It was held in Kashinath that even the Speaker does not have the power to review the decision taken by him under the 10th schedule of the Constitution. Under these circumstances, there is absolutely no question of the Deputy Speaker setting aside the order of the Speaker passed under the 10th schedule. It is also important to note that the Deputy Speaker himself disqualified from the membership of the Assembly by the Speaker, and he could certainly not have set aside the order passed against him and in respect of which he would be the beneficiary. There is no doubt that the Deputy Speaker had no authority at all to set aside the decision of the Speaker passed under the 10th schedule. The fifth question is answered in the negative.
Next paragraph.
In view, I am of the opinion that the view expressed by my learned brothers relating to the power or propriety of the Speaker taking a decision under the 10th schedule with regard to 14 members does not at all arise in these appeals. Well, let's look at another scenario. A notice is moved both against the Speaker and against the Deputy Speaker. It can happen, Madam. So, Madam, both will be disqualified. Then what happens to the 10th schedule? So this has far-reaching consequences on how our democracy is going to function in this country. And your lordships put it to me that the other concern is that he should not decide because he may be deciding in his own interest, Manas. That's what your lordships put to me. But Manas, the question is that as far as that is concerned, it is subject to judicial review. And the judiciary, if it says that he is wrongly disqualified, they'll be back in the House. And you can move a fresh motion.
But in the meantime, what will happen?
Nothing. You move a fresh
If
motion.
the disqualification is set aside,
Yeah.
what will happen? What will be the consequences?
No, they will come back. They will come back and move.
It presupposes that it is decided within reasonable time. But suppose in the court it takes time. Correct that. What will be the position
that's-
in the interregnum period?
No, Manas, that's for
The
courts.
government will be.
Well, I would request your lordships to not assume that courts will take. Manas, courts should not. This is our refrain has been throughout the last so many years that courts are taking time. Sometimes the court sits day after day to discuss what's happening in Rajasthan. When it comes to Goa and to some other assemblies, it takes years to decide. It's for the court to decide, not us, Manas. We expect the court to take up the matter immediately. But courts don't, unfortunately.
No, we are not on that. We are on the consequences.
But the point is,
Not sufficient that it will be set aside.
yes. And
It
then
may
will
be
come
set
back.
aside. But what will be happening in between?
But that happens in every case of disqualification. Manas. Why should this be different? Let's forget about this issue. In every case of disqualification, Manas, he'll come back. What's the difference in that consequence and the one that your lordship is asking me? There's no difference.
Actually, Mr. Sibal, then your broader principle is this, that is a matter of constitutional principle.
Yes.
A constitutional authority continues to act as a constitutional authority unless the Constitution treats the authority of that constitutional authority as having come to an end,
Correct.
namely after the motion of removal is passed.
Correct, correct.
Until a motion of removal is passed, there is no cloud on the functioning of a constitutional authority.
That's right.
And unless the Constitution has imposed any express or implied restraint, that should not be read in, because he for all intents and purposes continues to perform all the functions of a speaker until a motion for his removal is passed.
Yeah. Manat, how is the 10th schedule in any way, Manat, derogatory to what is happening in the House under 179C for a removal? Manat, the court has at two places remarked that these are two independent functions. Your lordships have seen that?
Yes, constitutional spaces.
Yes, there are entirely different spaces.
Basically, there were only two principal arguments, and the two principles which held favor with Justice Keir and Justice Mishra eventually. One was the expression,
Then members.
then members of the Legislative Assembly, which is really on a completely different issue. The second is something which requires a little more, deliberation, which is Justice Mishra's position that if you don't read this restraint, then within that period of 14 days, that is mandatory for the removal, Speaker could, by the exercise of the qualification, the conduct the outcome of his own, which your answer is that, look, the Speaker's decision to qualify judicial review. Whereas
there is no
a motion for the removal of a Speaker is not a
and there is no constitutional assumption, Malad, that we can make as a matter of law that the Speaker will act in his own interest and not in the interest of what is set out in the 10th schedule. You can't make a constitutional assumption of that nature. Either you say that the Speaker belongs to a political party, we know. The Speaker does not resign from that political party, we know. And yet we don't ever make a constitutional assumption that he is acting in favor of that party. We never make that. In ordinary cases, forget about this. Do you ever say that? No, never. Why? Because he is a constitutional authority. The 10th schedule has empowered him to perform that function. The constitutional assumption is that he will not be swayed by party considerations. That he is maybe a fact. But constitutionally, you cannot assume.
Well, one thing is very clear now, that para 193 of Justice Kehar's judgment and paragraph 238 of Justice Deepak Mishra's judgment, both the learned Chief Justice then were, make it very clear that according to them, once a notice for resolution of the removal of a Speaker is pending, a notice of the resolution for removal, then the Speaker cannot act.
That's correct. That's correct.
It's very clear.
That's correct. And that is based on, except that notice can happen. They don't fix the time when that notice takes place.
And logically, they are right in the analysis which they do, because they don't then bifurcate between the stage prior to leave being granted and after leave being granted.
That's correct.
So they know that, well, the judgment, they're very clear that it relates the disqualification on this, or the disability on the Speaker entertain a disqualification petition attaches the moment a notice for the removal is.
That's correct.
They don't then bifurcate it at the stage when leave is granted.
No, either they don't. They don't, which is the rules bifurcate.
Yes.
The reading of the rules bifurcate the manner in which this is to be considered. And they don't even tell us at what stage the notice is to be moved.
And the Speaker is not, according to, he doesn't cease to be a Speaker merely by a notice of removal given to him.
Correct.
Therefore, should the Constitution should it be interpreted to know that
The restraint
or disability or a cloud on his merely because of the fact that a notice for removal is given to him.
And as I said, Mullah, there will be other parties, Mullah.
Really, it's a matter of interpretation. Very short.
And there's the other issue, Mullah. There may be several petitions.
So anything else on the issue of, you've argued your point for reference, Mr. Sibal, anything else? So that we
No, Mullah, I'll just quite quickly, because there are some things that I have to point out. I've written submissions, I'll quickly read through them and then.
we can look at it. We can examine it. Now we are now looking at the other aspects. Should we come back after lunch?
Yes.
That we can. You will only focus on your submissions. How long now for you? It's about.
Well, not too long, Mullah.
Your submissions with respect to reference.
Sorry?
Your submissions with respect to reference to larger text.
Reference one.
Yes.
That's all.
We are not.
That's only reference. I'm not on the argument. Because if your lordship then decides to refer.
Mr. Sibal, just for a little clarity, you don't have to spoil your lunch because of this last question. Ask one of your juniors to give us just on a piece of paper the facts in Nebam Rebia.
We've done that.
Just bullet points on the facts.
We've done that.
Just to have a little clarity, because we're now looking at the facts by reading the judgment.
We've already filed
just on a paper.
additional compilation. One pager is already there.
All right, just that one pager we'll see, and then we'll go on to
Yes.
And then we'll call upon the others.
Yes. Deeply obliged. So I just wanted my lord to look at the decision in Polohan for a minute. That also has a bearing on this. Paragraph 110 of Polohan, which is in compilation 1, page
$74.
PDF 134.
134.
134.
Which para?
Well, let's kindly have it. May I, Your Lordship's have it? May I read it?
Yes, we have it.
Your late.
Kyoto judgment. Kyoto judgment.
Kyoto judgment. PDF 134.
PDF 74, but not.
132.
No, at the para 110.
Yes. I think 130.
Just your ladyship may have that.
नहीं वो नहीं. Start.
In view of the limited scope of judicial review that is available on account para
110. Yes, got it. Yes. In view of the limited scope
Yes.
of judicial.
In view of the limited scope of judicial review that is available on account of the finality clause in paragraph 6, and also having regard to the constitutional intentment and the status of the repository of the adjudicatory power, that is the Speaker Chairman, judicial review cannot be available at a stage prior to the making of a decision by the Speaker Chairman, and a key-timet action would not be permissible, nor would interference be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceedings, and such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. So, Kyoto assumes that there can be no interdiction by the court till the Speaker decides the matter. If you interpret 179 in the manner that Rebia interprets, you then automatically say that there is a stay as far as the Speaker dealing with disqualification petitions is concerned.
Yes.
It's the other problem.
Yes.
So you don't interpret one constitutional provision to derogate power of a constitutional authority vested in another constitution. So you have to actually provide a balance. And the only balance that can be provided is that he is not disqualified till such time as the resolution is moved and voted. That's the only balance.
Yes.
That's another point that I wish to make for your lordship. The other thing, Malas, that I am somewhat concerned about is that a 14-day notice is constitutionally provided. Then a 7-day period during the assembly. Now, Malas, supposing the 7th in the session for 3 days or 4 days. And if you, Malas, then of the judgment of Nabam Rebia, if you interpret notice provision in a manner, he is automatically for a year or 2 years. That's what's going to happen.
All.
The session will not be for 7 days, so it will continue till the next. And so, Manas, why would your lordships interpret these constitutional provisions in this fashion? By attributing or assuming that the Speaker will function in a manner when he's functioning as under schedule. The second problem that might happen is if you give notice to both the speaker and the deputy speaker, then there'll be nobody left.
Article 180, some other person will be appointed.
Can't be Malas under the 10th schedule.
Now 180 is, no, not 10th schedule.
I'm talking about the 10th schedule, Malas. Then what will happen? Because if the judgment is right, then there'll be nobody. With both, there'll be a notice for both. That also your lordship should not allow. The other issue with us is that now we are trying to balance between the removal of the speaker and the functioning under the 10th schedule. Let's take a case of small states. Most of these things happen in small states. You have a 5-member party, 2 of them move on to the other party, give a notice to the speaker, government falls, and those matters are not decided. So it has disastrous consequences. Then look at it from another standpoint. Look at it from the point of view of paragraph 3 of the 10th schedule, that's been repealed. What did paragraph 3 says? You must have at least 1/3. At least 1/3. That's repealed. Why? Because they thought that was also being misused. Now, if you interpret 179C in this fashion, that 1/3 comes back to the back door. Because 1/3 in an assembly can topple the government. So paragraph 3 having been repealed, Malas, 1/3 can still topple the government, and a notice under 179 will freeze the hands of the tribunal. So in a sense, you're bringing back, through this interpretation, a small minority in an assembly, who then, Malas, for reasons that we all know, go to the other side, and Malas makes the government fall. And then you say, no, but the speaker may have, maybe we should not have allowed the speaker this time because he may. Ultimately, if the speaker is removed, let's put it this way, if the speaker is removed, he's only removed from one office. There'll be another person who will be a speaker. But if an elected government, is actually toppled by this subterfuge, the harm to the polity is much greater. Look at it from that point of view. Because if supposing the speaker, and it is found that actually these persons were should be disqualified and are disqualified, speaker can't get back to the office. But when people who are disqualified, they are not disqualified, they can come back to the office. Judicial review is available. So from any standpoint, you can't balance the two. You're talking about one man moving a notice, sway one person, and you're talking about the whole polity and the whole 10th schedule being misused. Proper elected. There is no way that you can balance between the two. The only balance is that you cannot allow elected governments to be toppled.
Yes.
Well, as now I was eating to your Lord, I would like my note. Yes. I'll just quickly go through it. None. This is brief submissions on behalf of the petitioner for reference. Final note on.
Final note.
Serial number C in the PDF.
Revised supplementary.
Supplementary. Give it to
Do you
me.
have?
Whereas we had for everything. That was chapter 3, which is neighbor review. Now that chapter 3 is supplanted by this. This is what should be seen.
Yes, correct.
No, this is a special note. Why the reference should not be.
That's right. It should be made.
Should be.
Should be.
if your lordship had.
Yes.
It is respectfully submitted that there is an imperative need to reconsider the law laid down in Arabia, and it would be constitutionally impossible for the Speaker to adjudicate upon disqualification petition. That's plainly wrong according to us. Present case epitomizes the need for reconsideration, as the respondents misuse the observations to obtain key Tibet intelligence from this very moderate. So this is what happened. On 27th, this court said we'll give them till 12th July. So that on the ground of 2 days notice and Nabam Rebia. Para 110 of Kyoto Holohan says that you cannot before the final decision of the Speaker. That's what 110 says. It's only when during the proceeding that somebody is disqualified, then only, but not before. So the result, it is really the problem that is created by the order of this court on 27th of June, which is contrary both to Holohan as well as my submission that that ultimately led to the toppling of the government. So, Malad, the respondents then abused the process of law by unlawfully appointing a speaker in the assembly who is completely biased against the petitioner. Let's not go into this because we are not your lordships. That's only the pure question of law, so I won't be fair on my part. The impugned observations are prone to misuse for the benefit of defecting MLAs whose constituent disqualification under the 10th schedule can be avoided by disabling the speaker from proceeding with disqualification proceedings merely by issuing a notice. While discharging the responsibility under paragraph 6, the Speaker acts exercising a judicial power. On the other hand, the Speaker in the House functions as an officer of the state legislature, performing the role assigned to the rules of the House. The two roles performed by the Speaker under the 10th schedule as an officer of the state legislature under the rules of the House are distinct and separate. Constitution contemplates continuity in performance of both these. Holding that as soon as notice of resolution for removal of a speaker is moved, speaker is disabled from proceeding with disqualification proceeding under the The impugned observations have the effect of placing the distinction between the two roles of the speaker. The continuity in functioning of the paragraph 6, creating a constitutional bias in Kyoto. 5 judges held that interference in disqualification proceedings under para 6 would not be permissible at the interlocutory. The impugned observations by a bench of 5 judges in Rambal Rebi are in violation of the law laid down by Kyoto. Because to interdict proceedings under the 10th schedule on mere issuance of a notice for removal of speaker amounts to interference in disqualification proceedings at the interlocutory stage. The impugned observations are based on a misconception that the words all the then members in 179C mandate that the composition and strength of the House cannot be altered once a notice for removal of the speaker is issued. The interpretation is contrary to the plain language of 179. Import of 181. I come to later. Impugned observations, apart from being misused, can lead to absurd consequences. The above reasons elaborated here below, it is respectfully submitted that the matter be referred to 7 judges. Nabam Rebia, the notice of resolution for removal. Well, I've read those facts. Let's not, I'm not going to trouble you.
Well, just quickly, let's read para 12. It's just 2 minutes, like a
yes.
second.
In Nabam Rebia case, a notice of resolution for removal of Speaker of Arunachal Pradesh Assembly was moved on 19/11/2015 by 13 MLAs, 11 belonging to the BJP and 2 in. Thereafter, the disqualification petitions against 14 MLAs of the INC were filed before the Speaker on 7/12/2015, and the Speaker issued notice thereon on 7/12/2015 itself. The Speaker decided the disqualification petitions on 15/12/2015, whilst the Governor had passed an order on 9/12/2015, preponing the Assembly session to 16/12/2015 for taking up the notice of resolution for removal of the Speaker.
This should be message of the government.
This is the message of the Governor. In these circumstances, this honorable court considered the legality of the decision of the governor to prepone the assembly session. It was held that the governor's decision to prepone the assembly session was unlawful, as he had acted without the aid and advice of the Council of Ministers. Well, essentially what it said was that the discretion of the governor is enunciated in specific articles of the Constitution. Right? For example, Article 200. You send a bill, Manas, to the governor for his signature. He thinks that the bill requires further consideration. He can send it back. He can keep the bill and keep it pending for this consideration of the president. He can send the bill to the president. These are powers granted by the Constitution by the governor to act in his discretion. For example, Manas, under 371, 5th, 6th, 7th schedule, Manas, your lordship knows, not 7th, 5th and 6th schedules, governors has discretionary powers. So the court said that this discretion is enunciated by specific provisions of the Constitution.
If the issue really didn't arise in Nabam, Rebia, then should we refer it to 7 or construe 7, construe Nabam, according to you? You're still saying that we should refer it because it does comment on it.
Yeah, fine. If your lordship says it's sopater, not binding, respectfully submitted of the way misuse, unconstitutional consequences that may flow from the position that a speaker cannot proceed with disqualification if a notice for is pending. The impugned observations given an escape route to constitution gives an escape route to constitutional sinners. Commit the sin of defection and are then protected by the mere issuance of a notice for removal of the speaker, deputy speaker. Respondents in the present case preemptively moved the notice for removal of the deputy speaker, then exercising the functions of speaker on 22(6), as soon as they committed the acts constituting disqualification. In order to prevent the impending disqualification petitions against them from proceeding, the respondents malafide it in this regard as evidence from the fact that after appointment of their own speaker on 3(7), the motion for removal of the deputy speaker has not been taken up in the assembly till date. Implications of misuse of the impugned observations are particularly stark in the present, because the respondents who committed defection were large enough in number to tilt the balance of majority in the assembly and are present enjoying the fruits of defection by being in power with the support of the BJP. This unconstitutional majority has even gone on to appoint its own speaker, who is biased against the petitioners, thereby vitiating the entire process contemplated under the 10th schedule. Thus, the impugned observation is able to choose to decide their fate in the complete violation of basic justice. 10th schedule seeks to prohibit and prevent the constitutional sin of political corruption. It is recognized to be a grave threat to the very existence of our country, allowing us to MLAs to first then preemptively issue a notice for removal of the speaker, then appoint a speaker of their own choice, decide the disqualification petitions in their favor, nullify and obliterate the purpose of a principle of constitution achieving settled law, doing the constitution inhibition, what must adopt a purpose of interpretation. I am the spirit of the position to cure the. This principle was recently adopted in the context of the 10th schedule in the Karnataka Assembly matters, while upholding the disqualification of MLAs who had sought to avoid the rigors of the 10th schedule by tendering their resignation. Whereas what happened in the Karnataka matter was the disqualification notices were given earlier, resignation came later. Then they said to the court, now that I have resigned, there's no need for the disqualification. The court rejected it, saying that you can't, there's such a huge, by resigning, get away from the disqualification. So the law laid down by number. And it submitted that while discharging the responsibility under para 6 of the 10th schedule, the speaker acts as a exercising power. And this court has stated, Millers, and I would like to read this, where there is a list in affirmation of one party, this Justice Venkatachalaya, and denial by another, and the dispute necessarily involves the rights and obligations of the parties to it, and the authority is called upon to decide it, there is an exercise of judicial power. That authority is called a tribunal. if it does not have all the trappings of a court. In Associated Cement versus P. N. Sharma, main and basic test of whether the adjudicating power which a particular authority is empowered to exercise has been conferred on it by a statute and can be described as part of the state's inherent power in discharge of judicial functions. Denying this, there can be no doubt that the power which the state government exercises, 6.5 and 6.6, is a part of the state's judicial power. There is, in that sense, a list. There is affirmation of one party and denial by another, and the dispute necessarily involves the rights and obligations of the parties to it. The order that the state government ultimately passes its decision, and it is made final and binding. This is in contradistinction, Millers, to removal of a speaker. There is no list there. There's only a resolution which has to be passed by a majority. So the functions are entirely different. By those well-known and accepted tests of what constitutes a tribunal, the speaker or the chairman acting under paragraph 6.1 of the 10th schedule is a tribunal. On the other hand, the speaker in the House functions as an officer of the state legislature, performing the role assigned under the rules of the House. So you can't, having segregated the two roles, you can't say the impact of one will result in a tribunal not functioning. When the impact of one doesn't even allows the speaker to function continually and continuously till such time as the resolution is voted upon. It is submitted that the two roles performed by the speaker as a tribunal under the 10th schedule and an officer of the state legislature under the rules of the House are distinct and separate. In Nabam Rebia, the court rightly accepted the distinction between the proceedings for removal of a speaker and disqualification proceedings under the 10th schedule. Well, this I need not quote, you've read it. The import of the above observations is that proceedings for removal of the speaker, as an officer of the state legislature, cannot have the effect of interdicting the disqualification proceedings under the 10th schedule. However, the impugned observations have the effect of effacing this distinction between the two roles performed by the speaker, which is wholly impermissible. It is submitted that the Constitution contemplates continuity and performance of both roles of the Speaker as an officer of the legislature as a tribunal under the 10th schedule. As far as the House is concerned, when the Speaker is absent from any sitting of the House, provides that the Deputy Speaker or in his absence such person as provided under the rules, or in his absence such person as may be determined by the Assembly would act as Speaker. While the office of the Speaker is vacant, Article 180, Sub-Article 1 provides that the Deputy Speaker or in his absence a member appointed by the government perform the duties of the office of the Speaker. While any resolution for removal of the Speaker is under consideration, 181 provides that the Speaker shall not preside and the role of the Speaker is not by the Deputy Speaker. Or in his absence, such person was held to be prohibited from interdicting disqualification proceedings at the interim stage, except in exceptional circumstances mentioned therein. On the other hand, the impugned observations allow a defecting MLA, MP, whose fate is to be determined by the tribunal, to in effect interdict the disqualification proceedings by merely issuing a notice for removal of the Speaker. Thus, the impugned observations are in violation of the law laid down by Kyoto. Therefore, since there is a conflict between law laid down two separate constitutional benches, there is an imperative need to defer the matter to 7 honorable judges. The next point, Millers, goes into the history as to what are, because there are other provisions in the Constitution like 67. I let my learned colleague, Millers, Dr. Singh, that will tell your lordships as to how the very expression then has been interpreted in the context of other provisions of the Constitution. I will let him do that. But before I leave, kindly have a look, Millers, at their written submissions for a minute. The respondents. Their written submissions. Yes, written submissions. So you know what the flavor is to what they have said.
BB.
The question that will arise for your lordship's consideration, and squarely,
B.
which is why your lordship, that order of this court on 27th of June is squarely, Millers, in issue. because that led to the toppling of the government. Extended the response to 12th of July. So it automatically stayed the disqualification proceeding. That was the ground taken, that because of Nabam Reva, taken, just show that you cannot proceed, you cannot proceed. And secondly, that 2 days notice. That's also contrary to Kyoto. So a judgment of a court actually led to the toppling of the government. Otherwise, it would not have happened. And that your lordships will have to decide. Let's show to my, page 128. Convenience compilation, volume 1, page. Then what happened is, Millers, then we moved Millers on the 29th of June, because Millers, the government, the next day, Millers, they would have been sworn. On 29th of June, when we moved the court and said, look, don't allow this to happen, the court said everything that happens from now on will be subject to the outcome of the petition. Then that order, Millers, also is there. So all consequential acts after 29th of June. 29th of June, what happened? 29th of June, Millers, we moved. Yes. Convening of the assembly, Millers, for the trust board.
Compilation of justice.
Yes, see what happened.
They noted prayer and para.
Yes, they noted our, Millers, let's see, just read the order, it's important.
6.
Order compilation, PDF page 8.
8.
Not 8?
8.
What is the date of the order? 29th of
29th of June. Actually, it starts at page 7. It's my learned friend, Millers, who was appearing at that.
Which file?
Lordships have it, my lord.
Yes.
Justice Shah, your lordship.
Where compiled?
Page 7, PDF page 7.
By page 7. The instant read petition.
The instant writ, no, my lord, just, yeah, the instant writ petition has been filed under 32 of the Constitution for setting aside the directions dated 20th June, sent by the governor to the chief minister, as also the Secretary Maharashtra Legislative Assembly, which reads as special session of the Maharashtra Vidhan Sabha be summoned on 30th of June at 11 a.m. with the only agenda of a trust vote against the government. The business of the House shall be conducted in such a way that the speeches, if any, are concluded in a short period of time, and the trust vote is concluded on 30th June by 5 p.m. The voting by asking members to the counting vote completed under the Maharashtra Legislative Assembly rules. Proceedings have to be live telecast and appropriate arrangements are to be made to ensure the same. The entire proceedings of the trust vote shall be videographed by the Vidhan Sabha Secretariat through an independent agency and shall be submitted to me. The aforesaid proceedings shall be started on 30th June, 11 a.m. and no case shall be the same. In no case shall the same be adjourned, delayed, or members both outside and inside the Vidhan Bhavan. The writ petition was ordered to be listed. Made. Yeah. Subject to his furnishing the presenting the respective respondent. Pursuant thereto be appearing on behalf of the petitioner Tushar Mehta. Appearing on behalf and Mr. Kaul, learned senior counselors, appearing on behalf. To note, since the respondents have already put in appearance, the petition is ordered to be listed for hearing on 11/7 and to be heard along with writ petition 1/9, whatever the other petitions. Having given our thought on this, we do not find any ground to stay the convening of the special session of the Maharashtra Vidhan Sabha on 30th of June, tomorrow at 11, with the only one agenda of a trust. Proceedings of the trust vote to be convened on 30th of June shall be subject to the final outcome of the instant writ petition, as well as writ petitions referred to above. The special session of the Maharashtra Vidhan Sabha shall be conducted in accordance with the elections control. So everything that happened after 29th of June is subject to the outcome of the petitions. And everything that happened prior to 29th June is based on the order of 27th June, which granted in time till 12th of July. So in a nutshell, willy-nilly, to a toppling of an elected government through Navam Rabia. And contrary to law, by virtue of that judicial order on the 20th. Amalers, kindly have a look at their written submission for a minute. This is proposing your lordships have those written. Number. So the first 4 paragraphs are not relevant, Mother. And we come to preliminary page. On behalf of respondents proposing the referendum.
Yes.
So, page 3, the petitioner has misconstrued the entire interpretation. Page 3, para 5.
Yes. 3.
Respondents' written submissions.
Opposing reference to 7 judges.
Yes, sir. Page.
Now kindly come to page 3, Roman 3, paragraph 1.
Yes.
Petitioner has misconstrued the entire interpretation of Naval Media. Judgment does not in any way entitle the Speaker to decide the disqualification petitions pending before him, and therefore does not vitiate the procedure laid down in paragraph. Verdicts of a constitution likely to be disturbed. There is a sense of finality attached to procedure to overrule. Such verdicts is tedious and should be avoided. Verdicts are also not generally interfered with as the present bench has taken the entire judgment. State that they do not agree with the opinion of 5 judges, then refer to 7. In the present, cannot be made. Before divulging into the detailed submissions without prejudice, it is submitted that the question issue for reference of the judgment of this court in Nabam to 7 judges does not arise, as the judgment in Nabam Rabia was never applied. Never applied, and only argued in the present facts and circumstances of the case And further, no relief was ever granted to the respondents solely because of the judgment of Navam Rebia. While I show your lordship the petition where they say, I'll show that presently, but this is their case. The judgment of the court in Navam Rebia mainly focuses on the role of the governor and the powers of the governor with or without aid of the Council of Ministers. Inter alia, upholding the Constitution.
Yes.
Now, my lords, if your lordship looks at this petition.
So the effect of the order of 29th of June
Yes.
was that those disqualification petition would participate in the floor test
Yes.
on the 30th.
Yes.
And that's
And
what the
everything
government,
will be subject to the outcome.
and the government then resigned.
Yes. That's how they got toppled.
One
But there was no floor test.
One thing you should know.
But there was no floor test.
There was no floor test, my
No,
lord.
no, there was naturally because he resigned.
It was only 4th of June. July.
Floor test 4th of June.
July.
Conjunct the floor test.
One second, one.
The Chief Minister signed the same.
That's right. So fine, that's fine. Why would he?
No, the chief minister resigned because once those persons against whom they were
The
disqualified
foregone conclusion.
were permitted to participate in the
Yes.
floor test, the result was going to be, it was written on the wall.
Absolutely.
But for present purposes, your lordship should know, the matter started on 27th, not 29th. The 27th order is important.
Right.
Because
27 is the
that
first.
We've seen that first order.
was based on minutes.
That order gives time to reply to the disqualification notice until 12th,
Which is
the 12th of July.
Which was argument Mr. Kaur and I opposed each other, was based entirely on Navam Arabia. That you cannot, no, we were all there. And nowadays there is video recording also, based on the fact that you can, otherwise the disqualification can't be stopped. The idea, what is the foundation of the whole case? The foundation of the whole case is that I have given a notice to the speaker. The speaker cannot proceed.
According to you, the speaker had to decide the disqualification notices first. That time was extended.
Therefore, he could not decide.
And by the second interim order, the floor test was directed to be decided
It was
the
an
12th.
injunction against the speaker. The argument legally was based only on Navam Arabia. That you have a notice against you.
I was also there, Manoj, it's incorrect, factually incorrect.
Very well, it was based also on Navam Arabia.
1 second, no, 1 second.
Manoj, what's the point?
Argument was that there is a compliance with the rules which is needed to prescribe for not less than 7 day period. This is only 2 days period, for natural justice is going to be heard. So it is compliance of natural justice which was
1 second, hold on.
for passing of the order.
That also is in violation of Kyoto.
It doesn't stop.
Read the rate.
1 second, the time
All right.
granted up to 12. it
All
doesn't
right,
stop
all right, we'll just.
speaker from-
Let me finish quickly,
So
Manoj.
we are merely referring the correctness of number.
There's no point in doing all this.
Complete this, Mr. Siba.
Anyway, we don't have to go into the facts right now for deciding.
No, but I'm just mentioning to your lordships, Manoj, that their synopsis, first of all.
This is convenience.
Convenience compilation volume. I mean, the record speaks for itself. I don't have to say anything.
That is PDF page 131.
PDF page 131. 13.
There will be.
Yeah.
What are you showing us?
Is that, Manoj? Synopsis? 131, PDF. Petitioner is agreed by the notice summons dated 5th of July, as the same is grossly illegal, unconstitutional in utter disregard of the judgment of the court in the matter of Navam Arabia. And whether they quote, we hereby hold that it would be unconstitutionally impermissible for a speaker to adjudicate upon disqualification petition on the 10th schedule while a notice of resolution for his removal is pending. What's the point of seeing? Then see the grounds, Manoj, at page 167, PDF page 167. First ground itself. Because this honorable court in Navam Arabia, Deputy Speaker cannot disqualify any member on the 10th schedule during the pendency of its own removal resolution. That's the first ground. Then in the prayer, Manoj, the first prayer is that page 193. What's the point of saying to the court that no, that was not the ground? This is unfortunate. prayer, Malas, at page 193, Malas, PDF, is issue a writ of prohibition directing the respondent not to take any action on the disqualification petition under 6, seeking disqualification of the petitioners under 2(1)(a) of the 10th schedule, not to take any action on the same until the resolution for removal is decided. This is the first prayer. Now, the other prayer also was that 2 days notice has been given. That's also a prayer. But that also is contrary to Kyoto. Because Kyoto says you can't interdict the proceedings till the speaker decides. And your lordship knows in Ravi Nayak, the 2 days notice was upheld by the Supreme Court. But that's the weird. At the moment, what has happened is judicial orders passed time to time resulted in this. And the basis of all this, Navam, is why we voted the authoritative announcement so that
The correctness of a Nawab.
Yes.
Thank you. Anything else, Mr. Asabel?
Just minutes. I was just pointing out what they had said, so that your lordship knows.
They will,
That's
they
something
will
like
do
them.
what they will do.
All right. This is in defense terms of preemptive strike.
He said what they will do.
That's okay.
I shall try to give a new facet and to the rest assured. Your Lordship is on the Constitution bench, and whether your Lordship will refer, what are the fundamental errors your Lordship should have, I'll be very pointed.
You're on reference.
We are only arguing on reference. Only. There's no question of going anywhere beyond reference. Now, what is the first point I wish to?
Dr. Singhi, who are you appearing?
Well, we slotted in 10 petitions. A number of petitions I am appearing for.
Anyways,
I'll give a
we'll say you're appearing in the same.
If your Lordship were to have different councils slotted for different parties, your Lordship would never finish this matter. There are so many parties and so many people. But I'll give that slip to your Lordship,
Yes.
Court Master.
Doesn't matter.
Now, let's just give that. Yes, sir. Now, the first point is, that just consider, the very serious facets of which Devan Rebia has not considered. One is the manner in which the 10th schedule will become a nullity, etc. All that. My first point relates to another facet, which is very interesting acoustically. This your Lordship repeatedly at 10th schedule held that if Speaker S is only ex post facto confirmer of a disqualifying event which has already happened. So, when I cross the flow from here to here, I have incurred, fastened upon me, the stigma of disqualification in law. The adjudicatory process happens and leads to a judgment which is necessarily subsequent. But, and that's why Lordship Constitution says, it relates back. Case after case. Now, kindly see how uneasily Nabam Rebia will sit with this principle, which is not even considered remotely by Nabam Rebia. So, the Speaker is actually an ex post facto quasi-judicial confirmation of a disqualifying constitution, which is 3 months earlier. Every case where I disqualify somebody, he stands disqualified not from the date of my order, from the date when he incurred. Because the incurrence is A, I cross the floor. B, I do statements, I conduct, the Lordship says I also do. E, other things. The whole, I go to the governor, I do this. All that will be from that. Number 2, under the same point, I'm under point 1. The object is Dr. That is right. Two constitutional bench, the 2 judgments. What is the object of this? Object cannot get the fruits of your defection by saying that I am defective. I am scheduled today. You, for a variety of reasons, conscious or unconscious, near intervening, will enjoy the fruits of my not being declared a defector. That's the purpose of things. Now, if that be so, in notice given in most cases after the relating back date, I am now on the notice of Nabam Rebia. original 14-day notice. So a notice given by a person, hey, I went to Surat, then I went to go. The notice admitted is given subsequent. If the speaker will allowed to decide and be disqualified, this would be disqualified 3 days before giving the notice. Your lordships would not even have a notice in the eye of law from a disqualified member. Therefore, the notice of this one person notice, this general notice, can never be a trigger for disabling the speaker. Well, the first point is a matter of great moment. Your lordship harmonizes the entirety of 10th schedule. What Namam Arabia would do is, was one, it would render 10th schedule a nullity. Two, render law-like relating back a nullity. And all without considering the issue also. Those two paras, they are striking. What's the point of the lordship holding in constitutional tension? And there was this consequence following. First is Balas, case called Rajendra Singh Rana, a constitution bench.
Compilation.
PDA 834, first volume. Judgment compilation first. Just like it does violence to the peace made in the morning, it does violence to other concepts. Well, this is PDF page relevant 860. At 860, para is 34.
What is your PDF page number?
860 is the relevant page.
860.
It's a constitutional bench called Rajendra Singh Rana. The starting page, your lordship will notice 834. That your lordship need not go to. Go straight to 860.
Rana is a split case, I think.
I beg your pardon?
I think it's a split case. It's a case of a split, paragraph 3.
Split case. Yes. I didn't hear. Yes, correct.
Para.
Correct. Yes. 34, Malas. And this is followed in many cases. I'll only cite one more. As we see it, the act, may I read, Malas?
Yes.
As we see it, the act of disqualification occurs on a member voluntarily giving up his membership of a political party or at the point of defiance of the issue. Therefore, the act that constitutes disqualification in terms of the act of giving up or defiance of the rule. The fact that a decision in that regard may be taken in the case of voluntary giving up by the speaker at a subsequent point of time, doesn't mind underlining that, at a subsequent point of time, cannot postpone the incurring of the disqualification of the act of the legislator. Similarly, the fact that the party could condone the defiance of a whip within 15 days, or that the speaker takes the decision thereafter, those cases, not also pitch the time of disqualification as anything other than the point at which the whip is defined. The dates, the disabling notice. No, not in our case. Therefore, in the background, the object sought to be achieved, the 52nd Amendment, and on a true understanding of para 2 of the text, with reference to the other paragraph mentioned. The position that emerges is that the speaker has to decide the question of disqualification with reference to the date on which the member voluntarily gives up his membership or defies the will. So take a case where I come back, I say I made a mistake. If the speaker wants to punish him, the disqualification is occurred. They may do something, but in law, that act has happened. It really is a decision ex post facto. The fact that in terms of para 6, a decision on the question has to be taken by the speaker or the chairman cannot be that the question has to be determined only the date of the decision. An interpretation of that nature would leave the disqualification to an indeterminate point of time, and to the whims of the decision-making authority. The same would defeat the very object of enacting the law. Such an interpretation should be avoided to the extent. We are therefore of the view that the contention that error is only that it is only on the decision of the speaker that the disqualification is incurred cannot be. This would mean what the learned justices call the snowballing effect will also have to be ignored and the question will be decided with reference to the date on which the membership of the legislature party is alleged to have been voluntarily given.
So what is the sequitur, Dr. Singhvi, then?
The sequitur would be that here it is common ground that the date of alleged disqualification is 21st and 22nd June 22.
Just 1 second.
The legislature party meeting was called, whip was issued, you did not attend. Had the court not intervened, the speaker would have decided. And whether it is crystal clear, a separate line of judgments that define which is culpable. Forget that, you did not allow us to decide that, different matter. Now, admittedly, equally, the notice to the speaker expressing no confidence in him is submitted for the first time on 6, 2022.
1 second. Notice to the speaker to 622.
This purportedly was 21, but it is sent to the speaker at 22nd. The files show that. The files were later on produced. At 11:33 a.m. Put by hand. There is a separate noting on the file very clearly, which was discussed in court, that follows A, no MLA has given it. It's through a lawyer. Therefore, the speaker said, I have to check the veracity. All that is renders the notice. That's why it was not officially taken on record and acted. So, anybody gets in. You have to check whether an MLA actually.
You were to tell Twitter of your argument.
Now, the
basis of case which says they got the principle of
Relate-
relating it back.
Now,
According to you, the defection takes place in the violation. 2nd of June.
21st.
21st.
That is important.
21st.
Nabam Revia says that a mere notice, for the moment we are only discussing, mere notice disables the speaker. Your lordship does not have to, he can't touch the six. Speaker were to decide at any point of time, it would relate back to a time when there is no notice of disabling the speaker. There'd be no notice of disabling the speaker. It's a different matter, because the courts take time, speakers take time. Back doctrine. In fact, relating back doctrine is otherwise vital. Speaker wants to be part on this matter to decide on his own sweet will or after a minute. So it has to relate back to the act. The man will leave his seat from that act. In the day he leaves his seat, there is no notice by him. So can your lordships contemplate a notice of no confidence in the speaker by a person who has already lost his seat? There cannot be in law, Malak, a valid notice by a person who has incurred a disqualification which doesn't allow him to be MLA, but yet a purported MLA is giving a notice to a speaker. And that is the foundation of Nabam Arabia.
Then that determination simply.
Correct.
Speaker,
Will happen. No, but if it relates back, then it cannot be a simple kick off. The rightness of this kind of document. Either Nabam Arabia would have considered it. This aspect is not even considered by Nabam Arabia. And secondly, would have relevance. There would be a very strong reason.
Speaker, the notice of no confidence
is by a non-entity.
By a person who
has no status.
already incurred a disqualification.
That's the only. Otherwise, the lordship will not keep up the authority of the principle of relating back. And relating back is too far gone, into our jurisprudence for that to be questioned. As a matter of fact, lordship did relating back. Selectivity by speakers also. Time. You can choose to decide this case in 2 days. Here, para 92. In addition to the above, the decision of the speaker that a member is disqualified relates back to the (92 minutes, third line).
Yeah.
power of the speaker to decide upon a disqualification petition was limited by the Constitution. They quoted. At the end of it, they italicized it. The Supreme Court italicized that paragraph and emphasized. So this is my point one. And this by itself is sufficient to refer it because I can understand your lordship has a judgment on it and an error. No mind has been adverted to this because, as your lordship put it, there are two issues looked at: the then membership and generally the fact that you will be having people who are not members. Propriety of the speaker, the ethics of the speaker. That's the only two. It's a much, you are paralyzing the schedule, much larger issue, every part of the Constitution into account. Point number one. Is that, as has been argued, that what is the effect? The effect is not only that the tension, but the effect is that some articles in the same chapter of the same Constitution, without a non-obstant clause and without a subject to clause, are unwittingly held to be overriding the other article.
Has the effect.
Neither non-obstant nor subject to. Now just note the articles first. This is extraordinary because the same chapter. Your lordship never in interpretation says same chapter without a word will override the other provision 5 lines down the line. So, for the MPs, the chapter is different. Chapter 2, 102. Lordship will note that provision. Chapter 2, 102. Article 102. But for assemblies, the two provisions are 179 to 81, which my learned friend has read. My lord is, that is chapter 3. The Constitution. And just after it is 191, which is the provision by the 10th schedule. 191 bracket 2 applies the 10th schedule. 10th schedule is actually a code by itself. You will forget that it comes from the Constitution. It can't stand alone. So just see 192, 191 bracket 2. 191 bracket. A person shall be disqualified for being a member of the legislative assembly or council, a legislative council of a state, if he is so disqualified under the 10th schedule. Then you go to the 10th schedule. Just before this articles we read in the morning, 179, 180 and 181. Just before 10 articles before Manas. Same chapter. Your lordship have a non-obstant in either? Does your lordship have a subject to it? Does your lordship have an override or a subordination in any of these provisions which we discussed in the morning and now? Answer is no. 3 note, which your lordship will read. Final note on reference. The final note on reference, why it should be referred. In that, turn to para 59.
What page?
So that is page 20. The proposition, please note, the then assembly or the then does not include vacant. Is the point. Yes. May I in fact read for completeness from para 55? That says, now my lord remembers that para, let's take out that para, where Justice Kehar said that we don't have much discussion from the CAD. Just take out that para. You also read it in the morning.
Yes.
That para is
Should we see the whole of that D.5.3 from para 55?
That's right, from para 55. Just go to the side, para 190 at PDF page 1147 of Nabam Rebia. The learned then Chief Justice, Justice Kehar says, the Constituent Assembly was recorded any discussion of the above amendment. There is an error, with great respect. There is some more discussion which is Nabam Rebia. That will come separate. Correct. Now, I must clarify. The discussion was technically, the judgment is correct. The discussion was not in respect of that. In respect of the article with identical length. You should note that for the sake of completeness. Articles are identical for this purpose. 67, and obviously Article 67, 94, 180. That those articles apply here fully. The article 67, 94, and 183. Now come to paragraph 5. And I should be. Assembly. Discussions with 10 members. Constituent Assembly debates. Article 179, which was draft Article 153, based on Article 9. And we've got the page there. Area is observed. Constituent Assembly debates do not appear to have recorded any. The decision on the proposed amendment was, however, this Honorable Court, the term, the then members occurring in several other articles, like 67 and 89, debated in 8. Article 61 was in relation to the, that was Article 56, now 60, now 67. The Muhammad is similar amendment. Then that part of there's an interesting affix, last line of the complaints that Dr. is not hearing me. He wants your attention. Then he repeats it. Now come to paragraph 59. He was aggrieved. That part also was read. That part. Come to 59, the part also was not out in the Navam Rebbe also. Dr. Ambedkar is this. The word then is important. The word then means all members whose seats are not vacant. This was the crucial part. Again, I must overlook this. It does not mean members or present and voting. It's because of this provision that all and whose seats are not vacant. Their votes also have to be counted, that we have said passed by a majority. So, in one line, the learned Dr. Ambedkar is saying, the then assembly does not include seats made vacant or seats vacant. That's all he says. Now, it is submitted that he explained by the Constituent Assembly the word then is related to the composition of House of voting and not merely to members who are present in voting. Let's see two things here. At the time of speech, the only articles, just see those for a minute. It said that Dr. Ambedkar intended to apply to it. And it's the same article that Roshavik added the 10 schedule. It's in the same article. So turn to 91. My Lord has a species diverse disqualification. Some regional, some added in the middle, some added later. And the rationale of disqualification of Ambedkar applies. The Lordship will see 190 bracket 3. If a member of a house of the legislature of a state
193, 190.
becomes, may I read please?
Yes.
Becomes subject to any of the disqualifications in 191, 1 or 2. At that time, also there was a category which is important, resigns his seat by writing under his hand addressed to the speaker or the chairman as the case may be, and his resignation accepted by the speaker or chairman as the case may be. His seat shall thereupon become vacant. Mark the word vacant. Then there is another 4. If you are absent for 60 days without writing to the chairman and asking his permission, then also it can become vacant. That is item 4, subclause 4. Now go to 191 disqualification, the whole series. All disqualifications in generic terms stand on the same footing. You can be, your seat will fall vacant in each of these cases. Well, it's disqualified if A, he holds an office of profit, B, unsound mind, so declared, undischarged of India, voluntarily acquired citizen of the state, disqualified by or under any law made by Parliament. Then they make an exception, for office of profit that you are deemed not to be an office of profit holder, not relevant for lordships. And then they add clause 2, whereby that's how the 10th schedule came. 2. In the whole same list. So it's crystal clear that your lordship did not intend anything of the sort which Nabam Rebia felt. It could be something else. They did not appreciate this mistake. It's another error. This covers really broad detail, para 68 of my submissions. In particular, lordship may mark 59, 61 to 65. This is the heart of my submission. 59, 65. My fourth set of submission is on the vital question. My lord, Mr. Tibber has also answered partly, and I'll be really slight repetition here. Now there's been no repetition. Slight repetition, but a slight one. My lords, question. What is the harm which can be caused by not disabling the speaker? If I paraphrase and rephrase your lordship's question. Now, there are 5. This has been argued. Item 1. Bear in mind one thing. If in any case the figure can be only when that 7-day notice is there and then it is taken up for vote. The maximum rule is 7 days. Unless your lordship holds that the 14 days is valid, which is outside the vote. So, your lordship, keep in mind how much harm can be done in those 7 days. Only after that resolution, that we assume either way, the speaker acts earlier also, the first. I'll do it either. Lord has to do a balancing ultimately. I want the larger picture, please. Constitutional balancing and harmony is the most important. The Constitution doesn't provide for everything. It does it every day. Now, if there is an omission, simple answers are A, 7, and apart. That's only one. B, that lordships have called 10th schedule acts of constitutional sin. Not my word, is the Supreme Court 20 case. It's the constitutional sin and a political sin. By the whole act. Then the balancing is third, C, is on the one hand a stoppage, a cessation, a paralysis of 10th schedule, versus the speaker continuing to act in all ways except on the day of voting. The ultimate answer is D only. That if your lordships ultimately has a reinstatement, let's first as well as a disqualification, which is wrong. The disqualification is right. If it is wrong, then that ruling by either a court or anybody installs those members right back. And if You can reverse the speaker's continuance immediately. But can your lordships reverse the reverse the opposite? The speaker is removed today by a simple notice of that one case outside the session. The government falls. Exactly the facts of this case. A new government comes, a new speaker comes. Well, does your lordship's judicial review allow that reversal? So it is irreversibility versus reversibility, which your lordship will put in the calculus of balancing. If your lordship finds one is reversible, the other is irreversible, then definitely your lordship will lean towards the reversible, the interpretation which does not give a result of irreversibility. It can't be that there is no such particular provision of the Constitution. Your lordship does purposive interpretation every day, and in more so in constitutional law, teleological, purposive, in such gaps. So, a conjoint reading of constitutional sin, paralysis of the 10th schedule, the power of judicial rendering a wrong decision of the speaker reversible, the absence of any reversibility of a speaker gone, government gone, everything gone, then the only result is your lordship will lean in favor of the lesser harm. My lords can't say that there both are harms, big harm, then we can do nothing. Ultimately, the secretary of the other side will be that only, that do nothing. Which brings me, to the fifth point related to this. Purposive interpretation. Just one important case in this context. Lordship knows the general principle very well, but I'm not on the general principle. It is dealt with in para 25 of this note, which Mr. Sibbal did read. He didn't read the case, but he read that. I'm not only on that case cited here, just note that. Just note two things, brothers. Here there is cited Shrimant Patil, which you also will note starts at PDF 1249. PDF. But Jagjit Singh, you also will note on the side, is a case not cited in this para. And that starts at PDF 793. If you also will turn to 793, is it? Relevant at para 29, 811. What happened there was very interesting, completely by saying that we allow the mischief to go unchecked by a very simple purpose. Relevant page is PDF para 29, PDF 811. The members had not given a formal. They said that without a formal, that will be a matter of form. It requires to. Therefore, we hold it. Para 811.
The judgments?
This was the case 29. Sorry, 811. Relevant part of Jagjit Singh is the name of the case. 811 PDF. It starts with 793 PDF. It's 3 learned judges. Independent MLAs were involved. They joined the party, clearly prohibited under 2.2, but they say that we joined, there was no form, nothing. How are you saying we joined? There was nothing to act on. Now kindly see what the court says. 29. It is also essential to marry.
Yes.
It is also essential to bear in mind the objects for enacting the defection law, namely to curb the menace of defection. This is the larger purpose of calling it constitutional in so many cases, if there is no purposive interpretation. Despite defection, a member cannot be permitted to get away with it without facing the consequence of such defection only because of mere technicalities. The substance and spirit of the law is the guiding factor to decide whether an elected independent member has joined or not joined a political party after his election. It would not be a valid plea for a person who may have otherwise joined a political party to condemn that he has not filled up the requisite membership form necessary to join, not paid the requisite fee. The completion of such formalities would be inconsequential if facts otherwise show that the independent member has joined. We go by the spirit, we see the substance, etc. Then they hold that. That was my fifth point. My sixth point is a one-line point where the Lordship saw the word under consideration. Under consideration. My Lord the Chief Justice commented on it in article, under consideration.
Oh, that is.
181, your Lordship saw in the morning.
Yes.
Under consideration.
My Lord Chief asked a question. Clearly, Malas, two reasons why it should be interpreted only in one way. Reason number one, my Lords normally will not interpret different meanings for 181.1 and 181.2 unless your Lordship is compelled to do so by some language.
That I said, Dr. Singhvi.
Correct.
Said yes.
Second Malas reason is that the word sitting, under consideration goes with sitting. Sittings, Malas, we all know in Parliament, is daily sittings. Today's sitting, tomorrow's sitting, not a session, not an intersession. Sitting is the day. So clearly it relates to the day when it is taken up. And therefore, Malas, under consideration means that it is the day of taking up that resolution for removal when, Malas, for commonsensical reasons, he should not sit there. He will come down because one of the items of the agenda is his removal. So this is clearly the entire 1 and 2 are repeatedly used as sitting. So both these reasons mean that under consideration will mean the day the voting on that resolution is taking place for removal. The sitting of that day, for that purpose, for that agenda, for that time. Well, as the other provisions, your Lordship has noted in my para 53 of the note, 67, 90, etc. Those provisions, my Lord has got a list of. I'm just ending in 5 minutes. Well, as continuity is another point, not, well, it's been done in the morning, so I won't repeat. There is not one but several provisions, including 179 second proviso, Lordship noticed in the morning. The idea is.
Dr. Singhvi, anything else?
Yes, that's all.
Thank you, Dr.
My learned friend Malas may
Just
take
5
5 minutes
minutes,
because he
yes.
has been the architect of much of these submissions, Malas. So we are all benefited by them.
Just repeat whatever my learned seniors have argued. Because I have made a short note, which is A1, my lord, circulated yesterday. I put my thoughts together. I'll not repeat, my lord. I'll be very brief.
Thank you, Doctor.
My lord, the first error.
Which one? Where is your note?
Lord, it's A1, my lord, additional written submissions.
May I be excused for a short while?
Additional returns.
Last, my lord, in the PDF.
Brief additional details.
Yes, sir.
May I be excused for a short while?
Yes, Doctor.
My lords, one of the errors, lords, in the Nabam Rebia judgment is that, my lord, use different constitutional concepts, namely the concept of a notice under the proviso to 179C and the resolution for removal under 179C. No, my lord, it is
Brief additional details.
additional
Supplementary.
written submissions circulated yesterday.
A1.
It's A1 additional.
Oh, I see.
A1 WS it is called.
We got it.
I'm sorry.
What is A1?
Have, my lords, paragraph 5. I put it in proposition form.
1 minute, Devdutt.
I'm sorry.
Oh, Narasimha. इसमें A
Chief Justice.
Yes.
So, my lord, the judgment uses two distinct constitutional concepts interchangeably and applies the rationale, my lord, the purported rationale of 179C to the notice. which in my respectful submission, my lord, is totally incorrect. If your lordship straight away have, my lord, paragraph 191 of the judgment, it is, my lords, 1134 of the compilation, PDF page, my lord, 1147. Your lordships just have between placitum D and E. Kindly see the second sentence. A notice of resolution. Kindly see. I'm sorry. The relevant page, my lord, is 11.
Serial number 20.
26.
Yes.
26.
PDF page
1147.
1147, running page 1134. Now, the second sentence, lordships will kindly see, is para 191, a notice of resolution. Kindly see this, my lord, mark the words. A notice of resolution for the removal of the deputy, of the speaker or deputy speaker of the assembly would therefore have to be passed by a majority of all the then members. Lordships will kindly have my note, my lords, now, para 8. The term notice of resolution has been used at 7 places. And, my lords, paragraph 9, I have indicated this motion under 179C has been used in other places. And the rationale of the motion has been applied, my lord, to the notice in the, my lord's, ultimate directions, which is totally erroneous. I have given reasons, my lord, why. Now, my lords, kindly turn to paragraph 12. While the sub-Roman 1, while the resolution under 179C is to be passed by all the then members, there is no requirement of any quorum to give the notice under the proviso. Thus, even one member can give notice to move the resolution. I have said it, my lord. That is in the additional compilation. I will give the page number as well. Second, my lord, this notice can be withdrawn at any stage. If I can just invite, my lord, your lordship's attention to Rule 201 of the Lok Sabha rules, which is in this additional compilation, my lord, which was circulated yesterday, filed on 13th of February. It's a compilation of documents and judgments. It's serial number 3B, my lords. Compilation 4. Part 4. If your lordships have Rule 200, my lord, and the scheme, till, my lords, the motion is taken up, it can always be withdrawn. I'll just place that, my lord. Kindly have first Rule 200. A member, it's at page 25, my lord, of PDF 26. A member wishing to give notice of a resolution under clause C of Article 94 shall do so in writing. Now, kindly see 2. On receipt of a notice under Subrule 1, a motion for leave to move the resolution shall be entered in the list of business in the name of the member concerned on a day fixed by the speaker. Then, my lords, kindly turn to 201, Subrule 2. The member in whose name the motion stands on the list shall, kindly see the bracket, my lord, unless he makes a statement conveying unwillingness to move the motion when called upon to. So therefore, my lord, it is not a given that a notice which is given ultimately will result in the culmination of a motion. So therefore, my lord, the Constitution bench, in our respectful submission, ought to have maintained the distinction between a notice and the ultimate resolution. That's, my lord's, point number 2, my lord, which I have pointed out in that paragraph. Your lordships have seen Rule 11. I will not repeat that, my lord. The second point, my lord, which I wish to place, is the important concerns, my lord, which have to be addressed by your lordships. And as rightly fell from the court, my lord, there are two important constitutional concerns. One is that there can't be a hiatus. Constitutional adjudication, disqualification have to go on. At the same time, what fell from the Honorable Chief Justice, that can the Speaker be permitted to aid in the cause of his removal by selectively targeting certain members, disqualifying them, and thereby affecting the outcome of that resolution. That is answered, my lord, in the Constitution itself, and Nabam Rebia doesn't notice it. Please have a look at, my lord, Article 181 and 180, sub-article 2, and it completely provides an answer and show the relevant rule also of the Maharashtra Assembly. Kindly have a look at, my lord, Article 181. How Article 180, sub-article 2 applies is by virtue of Article 181. If your lordships have first 181, at any sitting of the Legislative Assembly, while any resolution for the removal of the Speaker from his office is under consideration, the Speaker, or while any resolution for the removal of the Deputy Speaker from his office is under consideration, the Deputy Speaker shall not, though he is present, preside, and the provisions of Clause 2 of Article 180 shall apply in relation to every such sitting as they apply in relation to a sitting from which the Speaker, or as the case may be, the Deputy Speaker is absent. Now kindly see 180 sub-article 2. During the absence of the Speaker from any sitting of the Assembly, the Deputy Speaker, or if he is absent, such person as may be determined by the rules of the Assembly, or no such person is present, such other person as determined by the Assembly shall act as the Speaker. So, my lords, to buttress the point that, my lord, when the motion is actually under consideration, not at the notice stage, there the Speaker is not disabled under the provisions of the Constitution. At the time when the motion is under consideration, it talks about some other officer, my lord, some other person being, my lords, anointed in the chair of the Speaker, and he shall discharge the functions of the Speaker. So therefore, my lord, Nabam Rebia ought to have considered that if there is a disability at the stage of consideration, and kindly have a look at the rules, my lord, which we have filed under Maharashtra Assembly rules. What happens if the Speaker or Deputy Speaker cannot act in certain situation? There is a panel, which the person from the panel will have to act, my lord. So the proceedings under the 10th schedule in any event can't be put in a limbo is the respectful submission. Kindly have Rule 8, my lord, at page 40. Yes, my lord.
No, Mr. Counsel, he will act as that person will act as a speaker.
Yes, my lord.
Correct? For the purpose of that meeting.
Yes, my lord.
Not for 10 schedule.
No, what I'm submitting is this, that ultimately, my lords, there can't be a hiatus. The constitutional scheme, my lords.
No, the question which was posed by the Honorable Chief Justice
yes,
was this, that after the notice, the resolution was moved, correct? Before it is taken, correct? He may disqualify, correct, the other persons and change the equation.
Correct, my lord.
That was the apprehension pointed out to you.
Right, my lord. The answer to that, my lord,
so that ultimately the motion against him, correct, for disqualifications will be defeated.
Correct, my lord. My lord, may I answer that, my lord? The counter answer to that is, a notice is not determinative. It can anyway, my lords, be withdrawn until the 14th. My lord, just two, three other points. Yes, my lord, just 2-3 other points. Your lordships, my lord, I have dealt with that. There can't be a hiatus, my lord, as far as constitutional proceedings are concerned. And lastly, my lord, the doctrine of necessity will apply, my lord, in this particular case, which has not been considered in Nabam Rebia.
Thank you, Mr.
Grateful.
So,
please, my lord.
Start tomorrow morning.
Yes.
We'll commence tomorrow morning.
Yes, my lord.
So,
Mr. Salve.
how long?
Yes.
Who's going to open?
Your lordships can hear me, my lord?
Yes, Mr. Salve.
Yes. Two things. I'll start tomorrow morning. I'll take 20 minutes and my lord, I promise to use the iPad to use which I have been trained by Mr. Agarwal from the Solicitor General's office.
You have been tech savvy from the beginning, you know that.
Just give us a moment, 2 minutes. I'll just wrap up my.
I mentioned item 12 on today's list.
So you may not. Thank you.
This is Sikkim Chief Minister's disqualification matter.